We're live.
All right, good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Wednesday, February 9th, 2022. We have 10 bills on the docket, and we'll start off today with Senator Bidle with Senate Bill 347. We'll then go to 371, 357, 336, 313, 317, 377, 279, 280, and we'll wrap up with Senator Hedelman, 315. So with that, we'll start off with Senator Bidle, Senate Bill 347. Senator Bidle, welcome. Here you go.
Thank you, Chair Smith and Vice Chair Wallstreicher and Judicial Proceedings Committee for hearing my testimony. And thank you for letting me go first, because the other night I was almost last. So I appreciate the reverse here, Mr. Chair. Senate Bill 347 is titled Anne Arundel County Landlord and Tenant Procedures for Failure to Pay Rent. So it's really about evictions. And in most counties, and in our county, in Anne Arundel County right now, when a family is evicted, if the family doesn't, for whatever reason, come and get their belongings, it gets put out in either in a front yard or in a space in an apartment complex, and it sits there. People will come and pick through it like vultures. Then it'll blow around the neighborhood and make a mess. And in some communities, like there was one I represented when I was on the county council, there were a lot of evictions. So on any given day, there were yards full of trash. Sometimes we'd go in on the weekends with big county trucks and pick up the trash. So we're trying to keep this from happening. Evictions are still going to happen. And you'll hear from Lisa Sarro, who's one of my panelists, about the fear when the eviction freeze is lifted, how many evictions we're probably going to see. So it's going to be a big issue here shortly. So the intent of the bill is to stop the belongings of the person being evicted from being placed outside in the yard. It requires the landlord's agent or attorney, to, whenever a judgment is entered in favor, to provide written notice to the tenant 14 days prior to the eviction date that's set by the sheriff. It provides the notice should be mailed by first-class mail, also posted on the door in a conspicuous place. It describes what the notice should contain: district court ejectment case number, the tenant's name, address, date, and date of the eviction. The bill also provides an additional 24 hours before any items left behind are considered abandoned. Now, this has gotten a little bit controversial, and my three panelists all have a different opinion on this. The sheriff doesn't feel like they have the time to come out a second day and oversee the 24 hours. The landlords aren't comfortable being there without the sheriff, but Lisa Sarro feels very comfortable giving people that one last chance to come and get things, or maybe some personal items they left behind. So that's going to be a sticking point. You have some amendments that the sheriff has requested. They're technical amendments. It's amendment number 853220/1. The sheriff is also requesting a 2-year sunset to see how this works. So hopefully I'm going to leave those things to the committee to work out. And like I said, my panelists are all from a very different perspective. One, Kathy Howard's from the landlords. Sheriff Frederick is with us, and thank you for working with me for the last few months, Sheriff. And then Lisa Sarro from Arundel Community Development Services, that's doing a lot to help prevent evictions. So I respectfully request a favorable report on Senate Bill 347 with the amendments that I've offered, and thank you, Mr. Chair.
Thank you very much, Senator Bidle, and we'll move on to your panel now. And first up is Ms. Sarro. Welcome.
Good afternoon. Thank you, Chairman Smith, and thank you, Senator Bidle, for putting forth this bill. I think that will make an incredible difference for Anne Arundel County residents. Anne Arundel County has perhaps the fastest turnaround from the date of filing failure to pay rent case to the hearing of that failure to pay rent case. Our judges are very proud of the fact that they closely follow the failure to pay rent statute. They shoot for 5 days, which is what the statute says, and they often have hearings within 5 days of a failure to pay rent case being filed. The landlord can then within 4 days get that writ, that warrant of restitution, and go to the sheriff to schedule an eviction. And our sheriffs are really very efficient They're a great partner to our program at ACDS, where we are running the Emergency Rental Assistance Program. They're helping us to deal quickly as we can with scheduled evictions, but we can't always make it. We don't always know when those evictions are happening. And in fact, the tenants don't always know when the evictions are happening. In many cases, more than you would expect, when my legal assistant contacts a tenant and tells them they're scheduled for eviction and we want to process their application as quickly as we can to get them rental assistance, that's the first time they learn they're being evicted. We usually have by then about 4 or 5 days notice at the most. This bill would prevent that. This bill would let the tenants know in advance. They can start planning, whether that plan is to move out, whether that plan is to get their rental assistance lined up, let us know that they need the assistance quickly, or to come up with funds elsewhere. That's the main thing that this bill would do. That extra day to gather up their belongings after the eviction has taken place would be crucial and would save so many families from losing medications, personal items that they just don't have a chance to get out before the eviction occurs. Sometimes, again, they're learning on a couple of days' notice, if that. Our sheriffs currently share their eviction calendar with us. We're so grateful for that. And that has saved so many evictions from happening. But the tenants, as I say, they don't know. We don't know based on the sheriff's calendar who is going to be evicted. We know where and we know when, but we don't know who. So we can't alert the tenants ahead of time, even though we know their property where they live is going to have evictions occurring. So the notice and the extra day, those are the key things in this bill that I really, really like. The additional parts that really are important are the information that needs to be provided to the tenant. One, the case number on which the writ was issued. That's important so that we can, or legal counsel or the tenants can match up the judgment and what's actually owed that the tenant has to pay to stay. They can match the judgment with that writ. We are seeing very often, unfortunately, writs being used on judgments that we, the Anne Arundel County Emergency Rental Assistance Program, have already paid. And that's not allowed. The landlord can't just use a writ.
Time.
Okay. So the amount owed is key. We need the tenants to know that so they know what they can pay and stay and prevent eviction. Thank you.
Excellent. Thank you very much. All right. Next, we'll hear from Mr. Fredericks.
Sure.
Hopefully you can hear me. So I'm Jim Fredericks. I'm the sheriff of Anne Arundel County, and I just want to voice my support for this. I appreciate Senator Beidel's effort in this. I think this is sort of a long time in coming. There have been some issues in the past, and I think that you'll see that there are going to be some increases in evictions coming up here in the future. And one of the issues with the sheriff's office is simply staffing and timing. One of the things that this bill allows is it allows for us to be able to have an even smoother flow for our processes here. And I think that what it does is it does several things. Not only does it benefit the sheriff's office in timing and allowing deputies to be freed up a little sooner. I think this benefits property owners. I think this benefits the tenants, which is really a critical piece for me too. I'm not interested in harming tenants at all. One of the things we want to make sure is that notice gets put out to tenants. That's a big piece of this new bill, and the property owners, they benefit because they don't have to be forced to put that property out on that same day. It benefits the people involved in the surrounding areas, and I did 26 years in law enforcement in Anne Arundel County before I became the sheriff, and one of the things I did was I served up in the northern part of the county, a lot of evictions up in that area. And one of the biggest issues up there was the picture, the backdrop of these evictions when they happen. It's a mess. It causes a lot of people to come into the area. when property owners don't do properly the eviction and then the cleanup of the property like they're required to by law now, later on, it just leaves a mess there. And it's something that I think this is going to allow for cleaner neighborhoods when it comes to evictions, going to allow for better timing for sheriffs. The communication between my office and ACDS has been great. I think it's helped a lot of people to avoid evictions. And I think that this notice is going to go even further to help with that. And I appreciate Senator Beidel's effort. My comments are brief. I hope that you find favorable light with this bill, and I'm happy to support it any way I can.
Excellent. Thank you very much. All right. Next, we'll hear from Ms. Howard. You're up. There you go.
Thank you. Thank you, Mr. Chair. I'm Kathy Howard. I'm the legislative co-chair of the Maryland Multi-Housing Association. And with me today is Kathy Dubinsky. She is property manager for a number of properties in Anne Arundel County and can give the bird's eye view of what it's like to be on the ground in dealing with these evictions. I just want to give you a little bit of background. Baltimore City has had a law that does exactly what this bill essentially does since 2008. It was called the Clean Streets Bill back in the day, and it has functioned incredibly well for that long period of time, and is very helpful to all of the parties involved. That includes the tenants, the landlords, and the city, where we can all sort of work together to make sure that people are aware of when evictions are actually going to take place. And one of the things that I think that was really helpful in getting that law passed was the fact that the Public Justice Center at the time, along with a number of other tenant advocacy groups, all worked together to put that entire process into law. And what you see now is clean streets after there are no eviction chattels in the streets, and tenants are getting notification well ahead of time so that they can, as Lisa said, make plans to figure out whether or not they're going to pay and stay or make other arrangements to be able to leave and keep their belongings intact. The one thing that MMHA has indicated is that there is a concern about the length of the 24-hour period. We think that may be too long, and we have offered several varieties of amendments to the bill, and we're happy to work with everybody to try to get that done. We ask you for a favorable report, and I'll leave it to Kathy.
There we go. We're switching over hosting authority here. We'll next move to Mr. Hill. Mr. Hill, you're up. I'm sorry, Kathy.
I think Kathy Dubinsky is next.
I see. Okay, Ms. Dubinsky.
Thank you.
Thank you. Good afternoon. My name is Kathy Dubinsky with A&G Management. A&G owns and manages over 3,000 apartment communities in the Maryland area, and of that, 1,578 are located in Anne Arundel County. We feel that SB 347 is great for Anne Arundel County. It'll provide transparency to our tenants with the advanced and final notice, to give them the time to make those decisions that are best for their families, whether to stay and pay or to find new housing. Two, it'll assist in providing that much needed time and expense savings to the sheriff's office. And it'll eliminate, as we heard already, the eyesores and hazards of the abandoned items being left in the public roadways caused by the individuals, those vultures that will just grab and run with everything they can. It's important to us to have good curb appeal, and I'm sure our neighbors appreciate that too. We are very concerned about that 24-hour reclamation period. One-on-one interactions with evicted tenants puts our staff and neighboring tenants at great risk. I'll share a story of an eviction that we had yesterday. We had a full live eviction at one of our Glen Burnie communities. The sheriff's department had to have 4 sheriff deputies come on site to defuse the situation, to execute this eviction. The tenant occupant was refusing to leave the premises and verbally assaulted our property manager and threatened her life. The property manager shared that in her 25 years of being in this business, she's never felt so intimidated and was really concerned that this individual was going to cause her bodily harm. In fact, as the tenant occupant was being escorted from the premises by the sheriff's deputies, she stated directly to the manager that it's a good thing the sheriff is here or I would blank you up. She stated this is one of the worst evictions she's ever experienced. We are truly, truly thankful to the sheriff's department for their presence yesterday in diffusing this situation. And this is why we are putting the amendments forward. Thank you for your time, and we respectfully request a favorable report with amendment on Senate Bill 347.
Thank you so much. We'll now move to Mr. Hill. Mr. Hill, you're up.
Thank you, Mr. Vice Chair, members of the committee, Matt Hill, Attorney at Public Justice Center. And I appreciate this bill. I appreciate the issues around notice to tenants that it's attempting to resolve. I actually agree with 90% of what Ms. Howard was saying. And I think we're favorable with amendments on this bill. And not surprisingly, we disagree about the length of the reclaim period. So from my experience in Baltimore City, we have had a lot of folks call us and say, I didn't know there was an eviction coming. And I understand that the tenant gets a mailed notice, but mail is not what it used to be. And so I do believe a number of my clients, when they tell me, I had no clue. And they lose vital documents, they lose medications. Landlords will at times say, pay me all the rent money, and then I'll let you get back in to get your diabetes medication. Those are the kind of situations that we see it's not every day, but it's not also infrequent either. And so just telling you from my Baltimore City experience, that's the way this has played out. It works very well in most cases, but in a good number of cases, it doesn't. I'll just point out that the 33 other states, and this is in my testimony, have reclaim periods longer than 24 hours. Pennsylvania has a 30-day reclaim period. Delaware, North Carolina, and District of Columbia, 7 days. So landlords, tenants in other states have managed to figure this out. We're asking for a 7-day reclaim period. Smaller points, notice should be consistent with whatever the reclaim period is. Right now, the notice just says all your property is abandoned. It doesn't give anyone notice of a reclaim period. Third, the bill talks about the sheriff a lot, but when it comes to executing the warrant, it talks about any official of the county entitled to serve process may execute the warrant. If that could be corrected to I think it intends to be the sheriff, but I just don't want private process servers executing warrants. One other problem we've had in Baltimore City is a dispute over whether or not notice was sent. The sheriff in the city does not keep a copy of the certificate of mailing that the landlord has to present. We'd suggest that the sheriff be required to keep a copy, just a photo of the certificate of mailing. And finally, there's often a dispute about whether or not the tenants exercise the right to redeem or pay and stay. If the sheriff's already bringing back the warrant because of a dispute over whether or not notice was received, they could also bring back the warrant if there's a dispute about whether or not the tenant has effectively paid and stayed. Thank you.
Thank you, Mr. Hill. We'll now look to the committee for questions. Senator Cassily.
You hear me? We're good? Okay. So sort of just a technical question, really. I'm looking on page 4 of the bill, lines 24 through 27, I guess really 24 through 30, and I guess whoever feels best qualified to answer this. I'm trying to understand. So it says the tenant has 24 hours following the execution of the warrant of restitution to recover their personal property. So I'm just, logistically, does that mean that we leave the tenant stuff in the apartment and But that wouldn't make sense because then you wouldn't be executing the warrant. See, my understanding is when the warrant's executed, the sheriff comes in and with the landlord's crew and they take everything out. So now it's out and now they have 24 hours to recover, but it can't go on the public street. So what's envisioned here? I'm just trying to understand the mechanics of this. That's all.
Senator Castley, what will happen after 14 days? So, the tenant has 14-day notice. So technically they have 14 days to remove their things or pay their rent. But after 14 days, the landlord can lock the premises. And now it's up to the landlord to dispose of what's left in the premises so that it's not on the street. So that's what the sheriff is there to do, is to see the lock changed.
Well, so I got that. Just trying to understand how the statute's written, because it says, so after we execute the warrant of restitution, which means normally, in my understanding, executing the warrant of restitution says the sheriff comes in with the landlord's crew, they enter the apartment, they take everything out, assuming the tenant hasn't redeemed, assume that's the case. They take everything out. That's executing the warrant of restitution. So now it's out of the apartment, but now the tenant has 24-hour period to any personal property remaining shall be deemed abandoned after 24 hours. So I'm just trying to understand visually, we've executed it, we've taken the stuff out, but it's not abandoned.
No, we haven't. We haven't taken the stuff out. We've locked the stuff. We've locked it up. The landlord.
Okay, so now does the tenant, just from the sheriff's perspective, if now the sheriff is gone, they just came, so all the sheriff is doing is coming locking the door, which is a pretty unemotional thing. He's locked the door and the tenant's no longer there. But now the sheriff's gone. The following 24 hours later, we're going to start taking that stuff out. I guess hauling it straight to the landlord. Seems like the sheriff's going to have to come back now because the tenant, nothing prevents the tenant from coming back. I'm just, I mean, the sheriff is there. Maybe the sheriff can. I just want to make sure that we're not setting up a system here that's going to cause unintended conflict, because somebody else had testified here how important it is that these things can go wrong, that your people sometimes feel very wronged and this is their personal property. So they can get violent about this. So it looks like what we're saying is the sheriff comes, they simply lock the door, leave the stuff in there. Then a day later, when the sheriff's not there, the landlord hauls the stuff off to the dump. And that could be a point in, so maybe somebody can comment. I just don't want a violence erupting after the sheriff is gone.
Mr. Chairman, can I respond? So actually, Senator, I don't know if you heard my presentation in the beginning, if you were already.
Yeah, I was there. I was listening.
Okay, so that's the sticking point, the 24 hours, because Ms. Sarah really supports that extra 24 hours after the 14 days. The sheriff says they don't really have the staff to come back in that 24 hours. And the renter, the landlords, as you heard, don't really want to deal with an angry tenant in that 24 hours. So, that is something that I think your committee needs to discuss. I do feel like, and Matt Hill's testimony actually conflicts with this, but if you've made sure they've gotten notice, you sent a certificate of mailing, you've posted the door, they have 14 days before the doors are locked. And the landlord can't carry it away then until 24 hours after that 14 days. But then the possessions are in the landlord's hands. If they haven't been reclaimed, the landlord now can give them away, take them to Goodwill, Purple Heart, put them in a dumpster, take them to the dump, whatever. They're the landlord's possession after 14 days. So this does expand the notice for the tenant. So they have 14 days to get their items. If they're not seeing the conspicuous notice on the door, I would wonder if they've come back to the apartment or the unit in that 14 days.
It just seems like from what we're saying here, if it's been on there for 14 days, the tenant hasn't got you in 14 days. By that point, what's 24 more hours going to matter? You've had 14 days, but anyway, okay, I got you. Thank you, Senator Bynum. Appreciate it.
Thank you, Senator.
Thank you both for that exchange. Any further questions from the committee? All right, seeing no questions, that concludes the hearing for SB 347. We'll now move to Senator Reedy with Senate Bill 371 as we allow folks into the room here. Senator Reedy, please go ahead.
Thank you, Mr. Vice Chair and members of the Judicial Proceedings Committee. It's always an honor to be before you. Many of you are former colleagues on the committee, and it's good to see everybody again. Got a pretty simple, straightforward bill. Senate Bill 371 is Carroll County Prospective Employers and Volunteers Criminal History Records Check. It was requested by our County Board of Commissioners. Our county law does not, or state law for Carroll County does not currently require all people who work and volunteer for the county to have background checks. As federal law changes, number one, it's become necessary to amend who gets a background check. We want to put this into our section of the code so that every time there's not a need to come back and pass a new law every time some different classification of people are required to get a background check to work for county government. But also the real intent behind this bill is to ensure that we cover people who might be working in sort of a volunteer or part-time capacity. There have been some incidents, we've seen them actually in the entire state. Carroll County specifically had one incident where there was a youth coach who was accused of misconduct with a minor, and he had had a similar incident in Pennsylvania, and that would have appeared on a background check. So our goal is to, number one, make it seamless and straightforward, that it's in the law now that everyone gets a background check, but also to be sure we just avert any of these kind of problems, these kind of issues, certainly before they happen again. So it has full support of all three of our Carroll County Senate delegation members, and I'd ask for your support. Happy to answer any questions.
Thank you, Senator. Next, we'll go to Commissioner Mike Fowler. Commissioner Fowler, you're up.
Thank you, Mr. Vice Chair, members of the committee. I'll have to say I'm not a commissioner, although I am here in their capacity as the legislative liaison for them in support of the bill. You should also have a letter in the bill file from the commissioner report. I think that Senator Reedy has outlined the intent of the bill pretty clearly. So thank you for the opportunity.
Thank you. I'm sorry about that. Questions from the committee? All right, seeing no questions, that concludes the hearing on Senate Bill 371.
Thank you, Mr. Chairman.
Thank you, Senator. Do we have Senator Benson with us for the next bill, Senate Bill 357?
Yes, she's here.
Hi, Senator Benson. Let me unmute you here and then you're good to go. Senator Benson, you are muted. If you could just click the button on your screen asking you to unmute yourself, Senator Benson. We got you. Go ahead, Senator Benson.
Thank you very much. Good afternoon, Chairman Smith and Vice Chairman Walt Stricker, and members of the Judicial Proceeding Committee. Today I present to you Senate Bill 357, a bill that is important to the well-being of Maryland's citizens. The purpose of Senate Bill 357 is to amend existing law governing matters about abused and vulnerable adults by establishing specific requirements and procedures within local departments of social services, including the Department of Human Service and the Office of Administrative Hearings, relating to the reporting, disclosure, investigation, and appeal of allegations and findings of abuse and neglect of vulnerable adults. It authorizes the Social Service Administration of the Department of Human Services to establish and maintain a centralized confidential database for abused and neglected vulnerable adults. It mandates the Secretary of Human Services to adopt regulations to protect the rights of individuals suspected of abuse or neglect by implementing a centralized database which prohibits a person from disclosing specific reports or records concerning vulnerable adult abuse or neglect, except under certain circumstances. Senate Bill 357 provides that any officer or employee of the Department of Human Services or a local department who releases information from the centralized confidential database be held guilty of a misdemeanor. The bill also requires, under certain circumstances, that the state's attorney provides detailed information to the secretary or a local director of a local department within a particular time after an investigation concludes. The bill also establishes a work group to study best practices for vulnerable adult registry concerning investigations and records of alleged abuse and neglect of vulnerable adults. The bill would ensure support and confidentiality for the most vulnerable population in our communities by establishing certain requirements and making necessary improvements to existing family law to enhance procedures to protect their privacy, their health, and mental well-being. It would strengthen the accountability of those working in social service agencies, including healthcare practitioners and law enforcement, by ensuring the integrity of the information contained in or released from the centralized confidential database. It provides specific boundaries for disclosure requirements and privacy protection for victims of abuse and neglect. Any caregivers, as well as those accused or exonerated or of alleged abuse and neglect, are held to be responsible for abuse and the neglect of vulnerable persons. The work group will study best practices for a vulnerable adult registry in Maryland. The work group would consist of uncompensated members who represent various agencies to research and implement any necessary procedures or best practices. The best practices will involve legal, financial, and technological and models from other jurisdictions to ensure an efficient process for abuse and neglected or vulnerable persons. Thus, I respectfully urge the committee to issue a favorable report for Senate Bill 357. Thank you so very much.
Thank you, Senator. Ms. Bresnahan, you are next.
Good afternoon, Madam Chair and members of the Senate Judicial Proceedings Committee. My name is Tammy Bresnahan. I am the Director of Advocacy for AARP Maryland. Real quick, you have my written testimony, and Senator Benson has been a real champion on this, as well as County Executive also Brooks. I just want to say that if now isn't the right time, when will be? Thousands of vulnerable adults live in assisted livings, nursing homes. People come into their homes, they go to adult daycare, you name it. What is in place right now for children who are vulnerable is the child welfare, the CPS background check, Child Protective Services CPS background check, so that if they've abused or neglected children, they cannot go into a situation where they're going to work. Every day, thousands of people go into long-term care and or other kinds of, facilities. We're all getting older. I don't know about you, but I'm getting older. We're all going there. Our parents are there, our grandparents, and we deserve to have a background check when they go to work for an agency that cares for vulnerable adults, whether it's in their home or it's in a facility. We don't have that right now. We don't know what's happening from jurisdiction to jurisdiction, because while the Adult Protective Services information has just been gone on statewide, we don't share that information, and they need to be able to do that. We need to be able to make sure that people that work with our vulnerable adults have no background with abusing them. So for that, I thank Senator Benson and all the other co-sponsors of this bill. I ask the committee for a favorable report on Senate Bill 357. If anything, we should have people working on this. Thank you.
Thank you, Ms. Bresnahan. We hope you feel better soon. Ms. Burnett, you're next.
Good afternoon. Thank you. Thank you, Vice Chair and members of this committee. I'm Gloria Brown Burnett, Director of the Prince George's County Department of Social Services, and I'm here to ask for your support of Senate Bill 357. Currently, the state of Maryland only tracks indicated maltreaters of children, and there is no reporting system for indicated maltreaters of vulnerable adults. This has left many vulnerable adults exposed to a population of maltreaters who move from setting to setting where they know they will be able to find vulnerable adults that they will then, that will be prey to them. It is estimated that 1 in 14 of cases of elderly and vulnerable adult abuse is reported, 1 out of 14. This means that our current environment leaves a gap and is conducive to a single maltreater having unlimited access to multiple victims. A registry would pose consequences for maltreaters, even if they are not criminally prosecuted. Would also serve as an additional screening tool for assisting community partners, as Ms. Bresnahan mentioned, to ensure that the people they hire are not coming with that baggage with them. Between July 2020 and June 2021, the Prince George's County Department of Social Services investigated 654 allegations of abuse, neglect, or financial exploitation against vulnerable adults. In several cases where we have indicated financial exploitation, the adult children of our senior clients have been found to be the maltreaters. The department refers these cases to our law enforcement partners with plenty of documentation, yet because these are their children, the victims will refuse to cooperate with the investigation. Without an abuse registry, these people are free to seek employment in organizations that deliver services to vulnerable adults. The National Adult Protective Services Association conducted a nationwide study of APS national registries. The study of existing registries revealed that registries reduce access of abusers to vulnerable adults and improves the hiring practices of providers. Also, common components of APS abuse registries include perpetrator notification and the existence of appropriate due process provisions. In closing, the Prince George's County Department of Social Services appreciates your consideration, and I ask the committee for a favorable report as Maryland seeks to unite with 26 other states in offering an abuser registry for our vulnerable adult population. Thank you.
Thank you, Ms. Burnett. That concludes the testimony for that bill. Now looking around for questions. Senator Heddleman.
Thank you, Mr. Vice Chair. I have a question for Ms. Burnett. You had mentioned that there is a registry for people who are convicted of child abuse. Can you tell me how that works? And is this patterned off of that in the same way? I mean, I know, so there's a sex abusers list. That's not what you're talking about here, right? Okay,
No.
Can you talk about how it compares to what exists for child abuse and kind of how you imagine it being used?
Sure. Currently, for when we conduct an investigation of abuse or neglect against children, if you are indicated for abuse or neglect, your name goes into a registry that is accessible only with your signature, your notarized signature on a form that gives us the option to release that information. So that registry is maintained by the Department of Human Services in a database. What we are envisioning is something comparable to that, where if you are indicated after an investigation by Adult Protective Services, if you are indicated for abuse, neglect, or financial exploitation, then your name would be held in that database, and the information would only be released if you're signed off on documentation asking us to share that history, as is the case with Child Protective Services.
So why would I sign off on that?
You might be seeking employment, and the employer requires it, which is often the case with CPS. So many employers require a CPS background check. And so in order to apply for that job, they have to sign the document that gives us the authority to release it.
Okay, just if you can, I'm trying to wrap my brain around this. So if I have a senior living business and I want to hire somebody, I do a background check like lots of other employers do. And I can see if somebody has been convicted, right?
Correct.
Of some kind of abuse that involves somebody older. Now you're not necessarily talking about convictions here, are you? Or are you?
I'm not talking about convictions, because many of the cases that we investigate do not go to court. They're indicated, and as I said in my remarks, Many times it might be relatives or people that are known to the client, and they don't cooperate with the legal process. So we may have indicated them and have the appropriate documentation to support that abuse, neglect, or financial exploitation occurred, but it does not make it to the level of prosecution.
But so I guess I'm trying to, if I can just one more question, trying to figure out that line between what keeps me, what would be on that list and what lets me not be on that list.
You wouldn't be on the list if we did an investigation and found that there was no abuse or neglect. You would only be on the list if there was an investigation that revealed with substantive documentation that abuse, neglect, or financial exploitation occurred.
By the local DSS.
Correct. And just like with Child Protective Services, which would be, this would be worked out with the work group, we would envision an appeal process just like we do with Child Protective Services.
Okay, helpful. Thank you.
Thank you very much, Senator Hettleman. We'll now move on. Who was next? Was it Senator Castley or West? All right, Castley goes first. You looked up first. There you go.
Thank you, Mr. Chairman. Just really one question here. So it appears, looking at page 5 of the bill, it looks like this is a hearing under the Office of Administrative Hearings, unless I'm misreading that. And then it says that the hearing shall be held in the jurisdiction in which the individual is alleged to have abused or whatever. And is that, I mean, my interpretation of Office of Administrative Hearings is they're all held in the central location in Baltimore County. Maybe I'm incorrect in that, but certainly not in every county. Just wondering if anybody can speak to that. Is that venue provision essential to this? Is that appropriate venue provision? Ms. Gloria Brown Burnett is raising her hand.
Yes, so currently it depends on the size of the jurisdiction. Many times the hearings are held at the central location, but they're also held in our local departments for Child Protective Services.
But isn't this a hearing now through the Office of Administrative Hearings, or is it a departmental hearing?
It's a hearing through the Office of Administrative Hearings. So with Child Protective Services, OAH conducts the hearing, but they conduct it at the local department.
Okay, and that's the standard. You all do that throughout the day?
Yes.
Yeah, I was unaware of that. All right, thank you. Appreciate your answer. Nothing else. Thank you, Mr. Chairman.
Very much, Senator. All right, next we'll go to Senator West.
Thank you, Mr. Chair. So the way these hearings are handled, the proponents go first with questions, and then the opponents go, but the proponents don't get a chance to respond to the concerns expressed by the opponents because they've already had their chance. So I think it's only fair to ask you a couple of questions about what the opponents are saying. The State Department of Human Services and the Maryland Association of Social Service Directors both have submitted testimony which is virtually identical. And also the Health Facilities Association of Maryland sort of has chimed in. The health facilities makes the point that a lot of the substantive parts of the bill are duplicative of existing state and federal law. And then the other two, or the State Agency of Human Services and the Association of Social Service Directors, strongly suggest that we delete from this bill the substantive parts, but leave the work group in place and wait to enact the substantive parts of the bill until after the work group has had a chance to consider everything and submit a considered report to this committee. So what do you think about that way of proceeding? To let the work group do its thing, hold off doing the substantive work, enacting the substantive part of this bill, and then wait to enact substantive provisions until after the work group has made its recommendations?
So I can weigh in on that.
Sure.
The work group is a great idea, and what we're seeking is enabling legislation that would also create the work group to work through the details and again report back. So we're not opposed to that.
It sounds like everybody's in favor of the work group, but the concern expressed by these other organizations is we could hold off enacting substantive provisions until after the work group has finished its work and presented its recommendations, and then move forward on the substantive part of the bill. So my question is, do you agree that we should lead with the work group and then come back a year from now and deal with the substantive provisions once we receive the recommendations of the work group?
My perspective is that we should enable the legislation, leave out the substantive part, to enable the work group, and then come back and put in what needs to be done after the work group has come up with a report and recommendations.
Great. Thank you so much for your answer.
Excellent. Thank you very much, Senator West. All right. Additional questions from the committee? Seeing none, that will complete the hearing for Senate Bill 357. Senator Benson, thank you very much, and thank you to your panelists.
Well, thank you. Thank you very much.
Excellent. Good to see you. All right. Have a good one.
Thank you very much.
All right. Next, we'll move on to Senator Carrozza is here. Welcome. Senator Carrozza is here to present Senate Bill 336.
Thank you, Mr. Chair. For the record, Senator Mary Beth Carrozza, proud to represent District 38 on Maryland's Eastern Shore. Thank you, Mr. Chair, Vice Chair Walt Stryker, and members of the distinguished Senate Judicial Proceedings Committee for allowing me to present Senate Bill 336, Custody Evaluators, Qualifications and Training, and to respectfully ask for your support for this bill, which would help ensure the safety and well-being of children and protected parents for this bill through court custody proceedings involving child abuse or domestic violence allegations. I wanted to point out, Mr. Chair, that the bill is a result of my serving and working with the members of the work group to study child custody court proceedings involving child abuse or domestic violence allegations. And this has been one of my most important public service assignments, given the magnitude of the trauma that many children and protected parents experience through these court custody proceedings. Again, the one focused on child abuse and domestic violence allegations. My bill, co-sponsored by Senator Susan Lee and Chris West, focuses on the work group's recommendations specifically dealing with custody evaluators. After hearing from parents, advocates, and legal child custody experts over the past 3 years, it has become clear there are no consistent qualifications or training for custody evaluators. This is especially concerning when the courts follow the recommendations in the custody evaluations in over 90% of custody cases. This bill simply requires certain qualifications and training requirements be met before an individual may serve as a court custody evaluator in these most sensitive cases involving child abuse and domestic violence allegations. The urgent need to establish basic qualifications and training for custody evaluations is heightened by protected parent Katie Spearman, who will painfully recount how the custody evaluator assigned to her was a school counselor with no formal training on cases involving sexual abuse. I know this committee recognizes that custody evaluators have an important role in assisting family law courts in determining custody outcomes in some of these most sensitive and difficult cases. We have an obligation to ensure a custody evaluator meets certain qualifications and has completed a reasonable 20 hours of training, 5 hours of continued training every 2 years. This training would include best practices to ensure that reasonable and feasible protective measures are taken to reduce the risk of traumatization or re-traumatization by the court process on the child. This is the second year I'm presenting this legislation to this committee. In an effort to work in good faith and address some of the issues raised by the judiciary and others, the bill has been revised to eliminate the master's degree requirement if other qualifications are met, and the number of hours of training has been reduced from 60 to 20 hours to be consistent with the number of hours in Senate Bill 17, sponsored by Senator West. The bill also has been amended to remove the term parental alienation and substitute a child's reluctance to have contact with a parent. Given that the Maryland General Assembly last session unanimously approved SB 159, sponsored by Vice Chair Walt Stryker, to require education and training requirements for animal control officers, 80 hours of training and 6 hours of continued training every 2 years. I believe we can take this common sense approach and move forward in approving SB 336 this session. We can ensure that custody evaluators meet certain qualifications and training requirements, which would result in better protecting the safety and well-being of those children, many who are experiencing trauma as they go through a custody court proceeding involving child abuse or domestic violence allegations. This bill is supported by Child Justice, and you will hear the strong testimony of the legal director, Paul Griffin, after mine, and by the State Council on Child Abuse and Neglect, Maryland Psychological Association, the Mid-Atlantic Panda Dentist Coalition, and the Women's Caucus voted on it and supported it this morning. Most important, this bill is supported by numerous protected parents and families who don't belong to a legal organization or advocacy group, but who have witnessed the trauma experienced by a child going through a custody court proceeding involving child abuse or domestic violence. We need to make sure their voices are heard, and this bill can help reduce the trauma on these most vulnerable children by ensuring that child custody evaluators, whose recommendations are given heavy weight by judges, are held accountable by meeting certain qualifications and reasonable training requirements. Mr. Chair and Vice Chair and members of the committee, I respectfully urge your committee for a favorable report on Senate Bill 336, and I thank you for your kind attention and consideration of this most important legislation.
Thank you very much, Senator Carrozza, and we'll now move on to your panelists. And the first witness I have up, as you mentioned, is Mr. Griffin. Is Paul here? There you are. Mr. Griffin, welcome.
Thank you, Senator. Thank you for having me. Thank you, Senator Smith, Senator Walt Stryker, Senator Carrozza, the members of the committee. I am Paul Griffin. I'm the legal director of Child Justice. Child Justice represents parents pro bono, free of charge, in custody cases involving domestic violence and child abuse. We're one of the few organizations in the state of Maryland to do this. Like Senator Carrozza, I was also a member of the work group. And in that work group, we had a statistic that stood out that was very concerning, that an estimated 58,000 children each year in this country are ordered by a court into some form of unsupervised contact with a physically or sexually abusive parent. Some of those children end up abused again. Others are subsequently killed by the abusive parent. Now, that's a national number. It's not a Maryland number, but we have no reason to believe that Maryland is somehow doing any better than the rest of the states in this country. In fact, those of us who deal with these cases firsthand can attest that they are not doing better. Maryland courts, which often follow the lead of a custody evaluator, will often award unsupervised contact or even sole custody to abusers. Therefore, we believe that this type of training that we're asking for is very important. We think the 20 hours initial training is very reasonable. The 5 hours continuing is very reasonable, particularly when it's compared to the animal control officers. We think that the amount of time we're spending our kids should be somewhere close to what they're doing. We think this training will help custody evaluators become aware of the signs and symptoms and effects of domestic violence and child abuse, but it'll also help eliminate the commonly held belief that a person who abuses his child's other parent, a batterer, can still be a wonderful parent in his or her own right and may be deserving of legal and physical custody even after domestic violence has been proven. Unfortunately, the science and past experience don't bear out either of those beliefs. We think this training will help disabuse that and other misbeliefs that are held. Now, I understand that there is some opposition to the bill. Some think the custody evaluators are already sufficiently trained. I can assure you, having done these cases for over 20 years, that I constantly deal with mental health professionals who are shockingly ignorant about domestic violence and child abuse issues. Indeed, many of these professionals still use tools that are ill-suited for these cases, such as the Rorschach ink block test or the MMPI. Now, these tests may be appropriate in a clinical setting, but they are woefully improper in custody cases with potential domestic violence or child abuse. Indeed, I know of one case where mother lost, I'll finish if I could. I know of one case where mother lost custody based partially on not doing well on a Rorschach test. Now think about that. Her answers to what an ink blot looked like had a devastating effect on whether she sought custody, whether she got custody and lost it to an adjudicated abuser. I ask that this committee give a favorable report to Senate Bill 336, and I thank Senator Carosa and Senator Lee for their leadership on this issue. Thank you.
Excellent. Thank you very much, Mr. Griffin. We'll now move on to Ms. Spearman. Welcome.
Hi, thank you all for the opportunity to testify, and Senator Carosa, thank you so much for sponsoring this important bill. I'm a protective parent. In 2015, my 4-year-old son disclosed to me that his biological father, my then husband, was sexually abusing him. My son explicitly disclosed the abuse he experienced to 2 other adults, including a therapist at a nationally accredited child advocacy center, and the abuse was also reported to police and CPS. The custody evaluator in my case was Dr. Gina Santoro. And before the issue of child sexual abuse was adjudicated, the best interest attorney, Renee Aids, sent an email to Dr. Santoro about my children's supervised visitation with their father. And she wrote, hopefully the boys will get filthy playing outside, so there will be no choice but for father to give them a bath. Thoughts? A copy of the email and additional context is in my written testimony. When Dr. Santoro was asked under oath involving her qualifications, did you take any course only focused on any type of sexual or domestic violence? No. Did you ever evaluate a child to see if he or she was a victim of any type of abuse? No. Have you ever been qualified as an expert in any type of child abuse? No. Have you ever been qualified as an expert in domestic violence or intimate partner violence? And Dr. Santoro, the custody evaluator, answered no. Judge Michael DePietro, the presiding judge for my case and the now judge in charge of Baltimore City Family Court, in his own words said, I know there was testimony suggesting Dr. Santoro did not have the requisite knowledge, training, and skills to perform this evaluation, given the nature of the allegations. I disagree. I do find her testimony credible and afford it great weight. As a result of Dr. Santoro's recommendations to the court, I lost full legal custody of my children, and I lost 50% physical custody. But to even get the case to trial cost me over $700,000. I had reported abuse as I am required to do by law, but I ended up having to file Chapter 7 bankruptcy due to legal fees, and I lost my home. My wages are still garnished by Renee Aids, the best interest attorney, who charged over $360,000 in fees. And my story is not unique, and it reflects how children and protective parents are harmed by the very systems that people turn to for help and protection. Thank you. I'll just finish. I support this bill. It's common sense legislation and a bare minimum standard. We need legislation to ensure custody evaluators have the requisite training. Thank you.
Thank you very much, Ms. Spearman. Thank you for taking the time to testify today. Next, we'll move on to Ms. Shaw.
I don't see her.
Okay. All right. Paul, you're gone. Is Dr. Killeen here? There you are. Welcome. I'm going to ask you to unmute. There you go.
I think I'm unmuted.
You are. We can hear you. Welcome.
Okay. Good afternoon, Mr. Chairman, Senator Carosa, members of the committee. My name is Dr. Catherine Killeen, and I am here today speaking on behalf of the Maryland Psychological Association. We strongly support Senate Bill 336. However, we are proposing some amendments. By way of background, I'm one of the few individuals that conduct custody evaluations pretty much on a full-time basis. It's the largest portion of my practice. And I do practice throughout the state. I have testified and conducted custody evaluations on the Eastern Shore and Western Maryland, at Central Maryland, etc. Over the years, a number of those custody evaluation cases have involved concerns about possible physical and sexual child abuse. I also do have a fairly extensive background in child sexual abuse, and I was the first forensic interviewer in Baltimore City's child abuse, not the CAC, Child Advocacy Center. And I worked there for over 15 years. Okay, so we want the committee to understand that we strongly support the notion of education in the areas of child abuse, child sexual abuse, domestic violence. What our concerns about the bill is that the specifics regarding training.
You have a brief moment to conclude, Doctor.
That the specifics regarding training are too narrow, too rigid, and will not serve us well over time. So we are strongly supporting training requirements, but we are recommending that the judiciary, in consultation with domestic violence and child abuse organizations, the Maryland Bar Association, and representatives from each of the licensing mental health professional associations, form a study group to come back with recommendations that are more flexible and will serve us into the future, not limit us when new research discovers new ways of doing things. Thank you very much to the committee, and a shout out to my Senator, Chris West.
Excellent.
Thank you.
All right, he's shouting out back. All right, thank you very much, Doctor. So that'll conclude the testimony for the proponents of the bill. We'll now switch to the opposition panel, and Mr. McAvoy, I see you here. Welcome.
Thank you so much, Chair and committee. Appreciate this. Because this bill is somewhat shocking. This bill is done in the vein that the SB 567 task force was done. You all recall that at the time that it was presented, that I told you it was an agenda piece. We found that it is. We also found that an amendment was offered for a father's rights advocate. None was chosen. I reached out to Senator Carosa, reached out to the Secretary of State, nothing was added. When we heard this testimony is as affirmed by the changes in the bill as it is today. When we heard this testimony with SB 17, it was voiced that the very DNA of this is dishonest. And that was shown by advocates who brought to you data on parental alienation, as well as a total debunking of Meyer's flawed statistics, which are a mess. But more so importantly, the House of Rules and Women's Law Center said we can withdraw everything from the bill except where we get paid. The dirtiest, stinkingest part of lobbying there. And this particular bill has everything but the kitchen sink added into it. It's like, how did you lose a case? Okay, let's write that down and put that into the bill. And that's the way that it looks. I have issues on pages 4 and 5. I'm going to try and wrap this up quickly. But I want to also highlight that both the MSBA and the judiciary are against the bill. They give you reasons why. The mandated training, right? So people are trying to get their 2 cents for training, and the courts are saying, no, thank you very much. We don't need the indoctrination, the propaganda. Page 4, we talk about stuff like things that are not at all relevant to most child custody cases. Do you have one-offs? Yeah, let's remember we have over 6 million residents in this state. So when you talk about flawed ideas like coercive control, lethality assessments, litigation abuse, and we don't discuss the flip side of that, that shows the bias of this bill. I'm going to skip down to this focus that abuse, allegations of abuse are false. You all have written testimony where Delegate Louis Simmons brought to you, where he dissected the vein of domestic violence in the state. Half of it, half the people who are the plaintiffs for these cases don't even show up in court. This is a flawed bill. I obviously have more to say. But remember, the entire vein of what was done by S 567 is flawed. I urge all of these type of bills to be shut down. Thank you so much for your time.
So thank you very much, Mr. McAvoy. All right, with that, that will conclude the testimony for Senate Bill 336. We'll now switch over to the committee for questions. Seeing no questions, that'll conclude the hearing for Senate Bill 336. Thank you very much, Senator Carrozza, and thank you to the panelists. All right, now we'll move on to Senate Bill 313, Senator Watson. Senator Watson, you're up.
Unmute. Thank you, Mr. Chair. Ron Watson here, Legislative District 23, here to present Senate Bill 313. This is a simple bill, the bill that prohibits the calculation of damages for loss of earnings resulting from personal injury or wrongful death from being reduced based on race, ethnicity, or gender. According to the National Association of Forensic Economists, 43.6% of economists use both race and gender specific data for projecting lost wages, and 90% use gender specific data. So it's no secret that gender and race wage gaps, continue to be an ongoing issue for us. Likewise, there is also the issue of longevity. And if anybody does a search and look at statistical data, you will find that African-American males have some of the shortest lifespans, with Asian Americans having the most. So what this bill, in a nutshell does is it tries to remove current, outdated, and inherently discriminatory methodology by removing, the race and gender of individuals from the calculation of awards. And it's almost analogous to what we did a couple of years ago with the Walter Lomax bill, where we worked to try to figure out a method for determining the compensation for somebody wrongfully convicted. It was a straight line calculation, but not at all based on race, gender, or anything like that. So that is the bill. Thank you, Mr. Chair.
Excellent. Thank you very much, Senator Watson. We'll now switch over to your panel, and we'll start with Ms. Marie Davis. You're up. Welcome.
Hello and good afternoon. Thank you, Mr. Chair, for allowing us to testify here on this bill. I'm going to jump right in and talk about the disparities that we see, and then Patrice will speak after me about the bill in itself and kind of go over it in general. But the disparities in the lost wage claims are most pronounced in the settings of younger Black plaintiffs, children, teens, young people coming out of college in their 20s. In the event of a catastrophic injury, a work-life profile is made for the plaintiffs. Plaintiffs' profiles are based on the current, calculated on the current population survey, which is compiled by the US Census and the Bureau of Labor Statistics. So when you see this compiled, what you see is work-life profile is calculated based upon earnings. And when you compare an African-American male with a college degree versus a white male, you'll see a white male, what they make per year averages about $105,000 per year. We'll see that same male, Black male, will only make $78,000 per year. Let's say you've got a catastrophically injured plaintiff. Well, if you look at the wage gap between a Black male and a white male over 30 years, that's over $900,000. What a disparity. If you're using those two tables to calculate wages, you will see a big difference, which is not fair. Essentially, the same calculation is used for Black male versus white male. You'll see a Black woman versus a white woman, and so forth. But please note, as you are looking to vote in favor of this bill, in the House last week, there was strong bipartisan support of this bill as well. So I just want to make sure that I want to bring that to your attention as you've seen, but it's clear the disparities between two different races are there. So I just wanted to bring your attention to that. And it's really unfair when the defense tries to use these tables to calculate the tables. Thank you.
Excellent. Thank you very much. Next, we'll move on to Ms. Clark, welcome.
Thank you very much. Good afternoon, Mr. Chairman, Mr. Vice Chairman, and members of the committee. My name is Patrice Meredith Clark, and I am a trial lawyer. I am testifying on behalf of the Maryland Association for Justice, and I request a favorable report on Senate Bill 313. As Ms. Davis just said, we all know that the existence and the persistence of racial and gender wage gaps is the result of historic, illegal, discriminatory practices. And we know that historically, women and people of color have not received equal pay for equal work. Now, I'm proud to say that as a society, we have made strides in addressing these wage gaps, and they have gotten smaller. But the systemic work and wage-based discrimination still exists, and it's carried over into the legal system. So as Ms. Davis said, when a person is injured and can no longer work, one of the things that they are entitled to claim is future lost earnings. And defendants in civil lawsuits use the wage gap tables that exist to argue for reduced wage awards to litigants of color and to women, simply because of their race or because of their gender or their ethnicity. This is wrong, and it must stop. Expert economists utilize multiple sources of data, including, as Ms. Davis said, the current population survey published by the US Census and Bureau of Labor Statistics. Now, that data is currently aggregated by gender, race, and ethnicity, and it reflects the persistent wage gaps. It is inherently tainted by racial workplace discrimination, and economists use that inherently tainted data to calculate the injured victim's future lost earnings over their work life expectancy. So what that means is that if I'm in a car with a Hispanic man and a Black man and Vice Chair Waltstreicher, and we are all four injured in the exact same way, we are all the same age, and we are all now unable to work, and we're all four dentists, I'm going to be awarded less money than my white male counterpart, and my Black and my brown friends are also going to be awarded less money. And that's because the data that is being used to make these calculations reflects years and years of systemic racism and gender discrimination. Using this data to discount the future lost earnings of women and people of color is wrong, but it's also unreasonable. And it's unreasonable because it necessarily assumes that these wage gaps will continue to persist. For these reasons, we request a favorable report. Thank you very much for your time.
Excellent. Thank you very much. All right, now we'll move on to, I know Mr. Enton is not here. Is that right?
Correct.
Okay. Then that appears to be the end of the witness list. And so now that'll complete the testimony for Senate Bill 313. We'll now switch it over to the committee for questions. I saw Senator Castley first, then Senator West.
Thank you, Mr. Chairman. I guess the questions for any of the panel there. So as I look at this, there's two possible outcomes. Assuming this becomes law, I see two possible outcomes. One would be, you have the entire universe, regardless of race, sex, we have this entire universe of people, and we just take all them and we average up. We take our averages based upon everything except for race and sex, and that becomes the table of potential earning. Or the other solution is we take that entire universe and we take out the Black population that you said is lower, or the female population is lower, and just say, here's the average, which I think the first one is the most likely, right? So the ultimate outcome of this bill, and I'm not really sure I oppose this bill. I may support this bill. I'm just trying to understand the outcome. It looks like the outcome of this would be that if you were a white male, and when this is done, you're actually theoretically going down a little bit because you got averaged in with everybody. And if you were a minority, you went up a little bit. Is that your understanding here?
I'd like to take a crack at this question. Thank you very much for the question, Senator. That would be the result if you were to take the amendments that are going to be proposed by the next panel. And the next panel is going to say that we should just take out the word reduce, because right now the bill says you cannot reduce the future lost income by race, gender, or ethnicity. And they want to say you can just take the average, but there's several reasons why that doesn't work and and one of them is what you just said. So first, as we explained, the data exists. It's based on the US Census. It's based on the Bureau of Labor Statistics. So stating that gender, race, and ethnicity may not be considered at all in a lost wage claim, it just would prevent an economic expert from using all of the data at all. And that can't be. But moreover, the MSBA and the Maryland Defense Council indicated in their comments, in their amendments, that the wage loss claim should use the statistical data to calculate an average of what women, men, and people of color earn. So they're saying take all comers, like you said, take all comers. And the practical implication, as you just said, is that a white man's wage loss claim comes down, would be forcibly reduced, while a woman or a Black or a brown litigant's wage loss claim only comes marginally increased, but it's still not in line with what the market pays white men. And it's not in line with what the workforce actually is, because we have the data that says this is what the top tier is earning. And so to say that we're going to forcibly reduce what white men are making and we're only going to marginally increase what women and people of color are making is not reasonable. And moreover, requiring economists to use an average of data that is based on historical illegal discriminatory practices, and that it necessarily encompasses, it includes the pay gaps, is just unreasonable, because it assumes that those pay gaps are going to continue in the future. So as Ms. Davis said, if you have a child who's catastrophically injured and he happens to be a Black child, and you allow an economist to say, okay, you need to calculate out 50 years work life expectancy for this child. And you say, okay, well, he's a Black child, so he's going to make $27,000 less a year. You're assuming that 50 years from now, we're going to have the same wage gaps. And that's an unreasonable assumption, because we know that the wage gaps have narrowed and that folks like you have put in place systems that will continue to narrow those wage gaps. So we can't allow a reduction. We should allow the data to be used. And that's why saying you have to take an average or that you can't consider anything is unreasonable. We need to take what the top earners make, which is what white men make, because in the future, we can assume that everybody's going to be on that equal playing field. I hope that answers.
So that's sort of preposterous what you're saying, to be quite frank with you, because there's going to be people making more and less. That's just the nature, that's reality. The goal of any discrimination bills isn't to bring everybody to the same income. It's to make sure that if you're in a lower income, it isn't because of your race or your sex. It's because maybe, the higher income, you're judged by your quality. And you speak about the data as though we just enacted the Civil Rights Act 2 minutes ago. I mean, we've been fighting discrimination for 40, 50 years now. And so granted, we have some way to go on in our society, but to pretend that that we're not going to have any more lower wage people, even when this is all done, assuming we had a totally colorblind society, a total sex blind society, you're still going to have some people making 100 grand and some people making 70 grand. And basically you could say, well, the 70 grand people could be making more, or the 100 grand people making less, but you're just taking away, you're just assuming that we're not going to have any lower income earning people. So that's just, you're cherry picking, but okay. I think I can see where this is going. Don't have any problem really so much with the bill as, what it's doing, but I agree that we ought to just assume that everybody's going to be making that higher tier, because that's not realistic. And if we're going to take these average, I think you're leaving out is a lot of this is not this, these tort recoveries are not just based totally upon these data. I mean, you've got work history, education, all those other things that factor in, where most cases those have a very heavy influence on the outcome. It's not just simply, other than the kid who's, whatever, where you're doing, they really have no work history or anything, or educational history. So yeah, I'm just not comfortable with the concept that we're going to assume that that we will not have any more people earning $20,000 less than other people, even when we have no racial disparity and sex disparity, because somewhere in the market's going to control. So thank you, appreciate it.
Can I just very briefly respond, Senator? 2 points. You are absolutely right that in the future, we're not assuming that everybody's going to make the same amount of money. That would be a preposterous assumption to make. And in fact, right now, the average earner is broken down by race, gender, and ethnicity, but that doesn't mean that every white man with a bachelor's degree makes $105,000 a year. I mean, some white men with a bachelor's degree make $500,000 a year and some make $36,000 a year. That's just the way it is. But when you're looking to project out what a plaintiff's lost future income is, you absolutely must use some set of data. And right now, the data that the economists have to use is aggregated by gender, race, and ethnicity, and it's based on historical data that has built upon itself. And so it's not that you're not going to assume that they're taking averages. It's that we're going to not reduce based on those those statistics that are necessarily based on historical inequality.
No, I got you. It's just that you speak of historical as though the Civil Rights Act was just enacted yesterday. That's how you look at historical. And we can take historical back 5 years, 10 years, or we can go back 50 years. You're going back 50, 60 years and talking about history. But I appreciate your answer. Thank you, Mr. Chairman.
All right, thank you very much. All right, we'll now move on to Senator West, and then we'll go to Senator Sidnor. Senator West, you're up.
Thank you, Mr. Chair. I don't know whether we're going to have testimony from the Maryland State Bar Association, but they would like to reformulate the substantive sentence in this bill in a way which sounds right to me, and I would like someone to comment on it. They wanted to reformulate it as follows: race, ethnicity, and gender may not be considered in a calculation of damages for loss of earnings resulting from personal injury or wrongful death. That seems to me as plain vanilla as possible. Is there some reason why that formulation is unacceptable to the proponents of this bill?
Ms. Marie Davis or Ms. Clark, I see Ms. Clark nodding, so I'll unmute you both and you can both respond.
Well, then maybe I just haven't understood, and I probably have not understood the dialogue between Ms. Clark and Senator Casserly, because I don't think we need to repeat that. But explain to me, if you would, this plain vanilla language, which seems to oppose the use of race, ethnicity, and gender in the determination of damages, why that's not acceptable.
Sure. Thank you very much for the question, Senator. And to be quite frank with you, the very first time I read the proposed amendment, I thought, okay, so that makes sense to me. And then I dug in and thought more about it. And I really started looking at the way that economists calculate these things. And if you say that there are two problems with it. First of all, if you say race, ethnicity, and gender may not be considered in a calculation of damages, it's already part of the data that exists. So it implies that you couldn't even use the data that exists now. And I don't think that's what they're saying, because you read the comments and they go on to say, under MSBA's proposed amendment, plaintiffs of certain categories whose awards have typically been less due to such considerations will be higher, and plaintiffs of other categories whose awards have typically been greater due to such considerations will be lower. They are admitting that that the goal is to take what is now the highest earning category of white men and take and forcibly reduce their future lost wage claims, and at the same time take women and people of color and only marginally increase their future lost wage claims. And so you're taking this average as opposed to eliminating the reduction, eliminating the ability of defendants to say, well, we're going to reduce your future lost wages because you're a Black man, or we're going to reduce your future lost wages because you're a woman. Instead of saying we're going to, they want to say, then we'll just take the average, as opposed to you can't reduce. Does that make sense? And I think Gwen Marie has something to add to that.
It's I got to say, the proposed amendment of the Maryland State Bar Association on its face is as plain vanilla as it comes. And you quoted a portion of their testimony or their memorandum, but you didn't quote the next sentence, which says MSBA believes that such an approach will allow for equal justice, regardless of the accidents of birth, et cetera. So apparently your view is that the State Bar Association's wording, which appears to me on its face to be completely vanilla, is not going to take care of the inequality that results from.
It'll codify it. Go
Maybe
ahead,
I'm just not getting this, but it's I don't know if I heard if somebody walked up to me and said race, ethnicity, and gender should not be used or considered in a calculation of damages for loss of earnings, I would say, of course not. I agree with that 100%.
I know. I understand. Go ahead, Gwen Marie.
But you don't agree with.
And
I can't
Senator
figure
West,
why.
Senator West, you know, with all due respect, even the Constitution says all people were created equal, and that really wasn't the case. It's vanilla on its face, but we still see that that necessarily may not be true, because right now, what we're using right now to calculate wages is the current population study, which is data compiled by the Bureau of Labor and the U.S. Census. That data is historic.
No, wait a minute. You're telling me that the only data that's compiled,
not the only,
segregated by race and ethnicity.
Correct.
There's
That's
no
what-
overall data. There's no.
Yes,
data.
that is what one of the major factors that is used to compile the data in order to get lost wage claims. It stems from there, and that data is not changing overnight. That data is there and it's compiled, and that's what's used. So that's why on its face, that vanilla statement, I wish everything could be so vanilla by saying, you know, what you just stated, that would be great. But even as you know, what we're still dealing with now is the Constitution and a vanilla statement like all men are created equal. It's not true. Thank you.
And I just want to add one thing to try and put the dot on the I, if I might, Senator, which is that if you say that you cannot use race, gender, or ethnicity in calculating future lost wages, you are necessarily saying that you have to take the average, right?
Okay. All right.
And the average.
You're not going to take men. You're not going to take women. You're going to take overall data.
Right.
Because
Because that's
overall
what
population.
that's what you just said to Gwen Marie, right?
Yeah,
You
I
have
got
to
that.
take everything. It's an average.
Yeah.
The average necessarily incorporates the wage gap because it exists now. Because we have historical systemic racism and gender discrimination, and the data now makes, let me just say, in
Senator West,
2020.
can I just say one thing? We'll just do it real simple here. Because the data that you're using to make these evaluations, it's impossible to decouple the historical vestiges of the inequalities in income. So while it seems like a relatively innocuous statement, it's impossible to decouple the two.
Perfect, Senator, Mr. Chairman, thank you.
So that makes sense. If it's impossible to
the statements, it's kind of a fiction because it's impossible to decouple something that's already been baked in.
Okay, that makes sense to me.
Okay.
But I still don't understand why you'd want to take race into account in determining damages. This bill is proposed to take race out of account in determining damages. We'll talk about it later.
Yeah. I appreciate it. I got you. All right.
Thank you, Mr. Chairman.
All right. We'll go with Senator Sidnor.
Thank you. After hearing the conversation, I think what I'm hearing is that this bill isn't necessarily trying to take race or gender out of calculations, but it's trying to take the discrimination because of race and gender out of the calculations. I see you shaking your head. So, and when I heard about the bill, I was fascinated because this is something that had been in the back of my mind for a number of years that I just hadn't had the time to introduce. The dean of my law school, Dean Giffords, had actually written an article about race and torts and how our tort system has a lot of this stuff kind of baked into it. And I believe there was an article that was written, said, how much is your injury worth? First, tell me your race, gender. So, I mean, we know this is an issue, and I appreciate your explaining. I appreciate Senator West asking the question, because I think most of us probably looked at it like, yeah, sounds very reasonable. So I also appreciate your explanation because you the dot on I, as you said. So I just wanted to say thank you all for your testimony. I have no question.
Thank you, Senator.
Excellent. Thank you, Senator Sidnor. All right. Additional questions from the committee? All right. With that, then that'll conclude the testimony and the hearing for Senate Bill 313. Thank you very much, Senator Watson, and to the panelists. All right. We'll now move on to Senate Bill 317 with Vice Chair Waldstreicher. Or West, that's you, right? Is that you? Senator 317. It's West and Waldstreicher.
Yes, Western Waldstreicher, but I'm afraid came first, so I have to explain this bill.
There you go.
Well, thank you, Mr. Chair, for allowing me to present Senate Bill 317. This bill was introduced last year as Senate Bill 735, which passed the Senate unanimously. Unfortunately, it passed the Senate after crossover, and it never was voted on in the House. So unfortunately, we need to deal with this bill a second time. It's very, very complex, so much so that you could say that only an estates and trust lawyer could possibly understand this bill. And the fortunate thing is only estates and trust lawyers are ever going to read this bill. Nobody else will pay any attention to it. So let me briefly explain what the bill does. First, it amends section 18-214 of the state government article to permit wills to be electronically notarized. So this bill just confirms what we did last year when we when we changed section 4-102 of the Estates and Trust article to permit wills to be electronically notarized. Because we didn't change section 18-214 at the same time, this bill conforms 18-214 to what we did last year. Secondly, the bill will allow a notary public located in the state of Maryland to use communications technology to take an acknowledgement of a signature on a tangible record that is physically present before the notary if the record is displayed to and identified by the remotely located individual during an audio-visual recording. I told you this was a complicated bill. Third, the bill increases the maximum fee the Secretary of State may establish for an original notarial act from $4, which it's been for heavens knows how long, to a much more realistic $25. Under current law, the Secretary of State is responsible for regulating and establishing the fees for original notarial acts, which cannot exceed, according to current law, $4. Fourth, the bill specifies that a notary public located in the state may use communication technology to administer an oath or affirmation to a remotely located individual, so long as the notary public identifies the individual, creates an audio-visual recording of the individual taking the oath, and retains the audio-visual recording. And finally, it should be noted that this bill will benefit small businesses that provide notary services by allowing them to increase their fees to a reasonable level in today's society. I'm so pleased, and I'm tempted to say relieved, that 3 members of the Maryland State Bar Association's Estates and Trust section will once again be with us this year to further explain the bill and answer questions of the committee members about the bill. So with that, I appreciate the committee's consideration of Senate Bill 317 and will be more than happy to answer questions or refer them to the MSBA experts on the issue. Thank you.
Excellent. Thank you, Senator West. All right, we'll now go to your first panelist with Ms. Hubbard. Welcome back. There you go.
Thank you. Thank you. My name is Christine Hubbard, and I am the chair-elect of the Maryland State Bar Association Estate and Trust Law Section, here in favor of Senate Bill 317. This bill has 4 sections in our hopes to amend ROLONA. I will cover 2, and Sarah Call will cover the other 2. The first amendment is to remove the exclusion of wills and trusts from being electronically notarized. Our new Electronic Wills Act cannot be used as a result of this exclusion because that statute requires all electronic wills to be electronically notarized. So there's that conflict. We cannot use electronic wills in Maryland as a result. Of course, it's a problem, but the real issue here is that it's time. We have multiple layers of protections within our Electronic Wills Act to now allow Maryland citizens, attorneys to remotely notarize wills and trusts in a safe manner. The second point I'm going to cover is an amendment to correct a conflict within two separate sections of RELONA. One section, 18-214, clearly states that when performing an electronic notarization, the notary may identify the witness with personal knowledge, affirmation of a credible witness, or presentation of identification, a driver's license. It goes on to say that if and only if you use that driver's license, that presentation of identification, you also must use identification of identity proofing and credential analysis, both as expensive and time consuming. However, the problem is when you turn to the next section, 18-223, it broadly states that whenever you undertake an electronic notarization, you always have to use identity proofing and credential analysis. So this is in conflict. So for these reasons and for the reasons that Sarah's going to discuss, we ask you to, please vote favorably on Senate Bill 317.
Excellent. Thank you very much, Ms. Hubbard. And we'll go on to Ms. Call next. Welcome back.
Thank you very much. Good afternoon. My name is Sarah Call. I'm also representing the Estate and Trust section of the MSBA in support of Senate Bill 317. And going back to the emergency order, when we were using remote notarizations to sign estate planning documents that required a notary, we were able to use remote ink notarizations known as RINs. And this bill would allow remote ink notarizations to continue. I can certainly explain more about how those work under the bill, but basically having the safety and ease of having an audio-visual conference, but also having the simplicity of having pen and paper has been much more useful to estate planning practitioners. A RIN mimics the process for an in-person notarization, but does not require our clients to have any particular technology or be tech savvy or engage with a specialized notary. So we appreciate having both options of being able to have a remote online notarization and also a remote ink notarization, but that pen and paper option is the one that our members have especially come to rely on. I also want to draw your attention to the section of the bill dealing with the fees. As Senator West mentioned, it allows the Secretary of State to have more discretion in what notaries can charge. It's especially important for us because we have had difficulty in finding notaries who are willing to do the remote electronic services because there's a subscription service that's necessary for those notaries to be able to perform those notarizations. So in some cases, the notaries were losing money on having to do each notarization done electronically. So that is why it's especially of interest to us that notaries be able to charge in a way that matches the current economics. So to be clear, the bill doesn't automatically raise the rates. It just gives the Secretary of State the ability to raise those rates. Finally, just to point out, the bill also does validate that there are the remote notarizations that occurred during orders are also valid. And then to allow clients to take advantage of remote notarization and allow remote notaries to be accessible, I encourage a favorable report of Senate Bill 317. Thank you.
Excellent. Thank you very much. All right, next we'll go on to is Mr. Weintraub here?
I don't see him.
Okay, great. Well, now we'll move on to Mr. O'Connell. Welcome.
Sorry. Good afternoon. My name is Bill O'Connell. I am the legislative chairperson for the Real Property Section Council of the Maryland State Bar and the past president of the Maryland Land Title Association. We support this bill for a number of reasons. One is to fix something that should have happened last year in terms of the electronic wills. The other is to allow the Secretary of State to increase the allowable charge for a notarial act. $4 is just woefully too low to complete an electronic notarization. It's not possible to do that. Computers know no boundaries. So by refusing to allow the Secretary of State to increase the charge, all you're going to do is force people to use notaries from out of state who don't have that restriction. And we accept notarizations that take place in other states all the time. So we're not doing our citizens or consumers any favors by not allowing the fee to be set by the Secretary of State. The Secretary of State can do their own analysis as to what a reasonable charge is and periodically adjust it. If the cost of doing these things goes down, they could lower it. If the cost goes up, they could raise it. But it doesn't do us any service not to allow the fee to be increased. The other thing with the remote ink notarizations, that is all the same protocols will be in place for that as it is for electronic notarizations. Today, if the notary knows the person who is signing the documents electronically, they don't have to run through the whole credential analysis and identity proving. And that's going to be the same with this RIN process. To some, I guess it wasn't clear, so they want to make it more clear, but at the end of the day, this current law is allows for that. Anyways, so thank you. We ask for a favorable report.
Excellent. Thank you very much. All right. Next, we'll move on to, is Ms. Howell here?
She is not. She's testifying on another bill in the House.
Got it. Okay. So then looks like if Mr. Weintraub's not here, then that looks like that'll conclude the testimony for Senate Bill 317. Now I'll switch over to the committee for questions. Seeing none, that will conclude the hearing. For
I think Ms. Howell just entered the waiting.
I see her there. She just got here. All right.
She's, yeah.
Ms. Howell, I see you've muted yourself here. I'm going to ask you to unmute. You are up next. Welcome. I know you kind of just got here, but welcome.
Thank you, Chair. Yeah, I was stuck in the waiting room for a little while, but I'm happy to be in front of the committee talking about Senate Bill 317. I am an estate planning attorney in Maryland and member of the Estates and Trust section of the Bar Association. During COVID, I was one of the attorneys here who performed a lot of remote notarizations. And what I quickly came to realize is that this is an essential thing for estate planning that shouldn't exist only in the context of a pandemic. While it was obviously critical to have this option during a pandemic, I dealt with many clients, including individuals who are critically ill and regardless of the pandemic would not have been able to come to my office to sign a will. I dealt with individuals who have young families and to take time off work and find a babysitter in order to come in and do an estate plan would equally have been very difficult for them. These are just a couple of examples of individuals who would be directly served by the modifications that we are proposing with Senate Bill 317 that would allow for these remote notarizations, both purely electronically, but also the remote ink notarizations that many of my clients would prefer, seeing as they would struggle with the requirements of a purely electronic notarization. I'm sure that the committee can imagine the number of times I've walked 80-year-old, 90-year-old people through how to share their screen on Zoom. And it's something that many people struggle with regardless of their age and should not be a barrier to receiving these remote notarizations. Senate Bill 317 would resolve that, as well as Chris pointed out with her testimony, resolve the confusion about whether the strenuous credential analysis and identity proofing requirements are applicable in all situations, or only, as the original law anticipated, in the events where ID is needed rather than identification through personal knowledge or testimony of a credible witness. Thank you for your time, and I would strongly encourage a favorable report on Senate Bill 317.
Excellent. Thank you very much, Ms. Howell. And unless we have Mr. Weintraub here, that will then conclude the testimony for Senate Bill 317. Switch again back to the committee for questions. Seeing none, now we are really concluded with the hearing. So thank you, Senator West, and the panelists. Ms. Howell, thank you for squeezing us in. Glad you made it. All right, now we'll switch over to Senator Lee with Senate Bill 377. Senator Lee, you're up.
Yeah, thank you, Mr. Chair. Can you hear me? Mr. Chair? Okay. Senate Bill 377 will ensure Maryland marriage records honor the individual and the union faithfully. This is just a minor change in the code, but a major relief to many proudly married Marylanders who transitioned their gender identity after getting married, but have stayed with their partners. Of course, love is love, and marriage should be respected for the bonds that tie, not just tie us to the past, because this problem hasn't been public before. So this bill just fixes this. Presently, Maryland marriage records reflect the names and gender of two individuals at the time of the actual issuance of the original marriage certificate. There is not a process to alter such documents in the event of a name change or in the event of a change in gender identity. If the clerk is amenable, some changes may be available, but the change may be presented as an amended document and not as a completely new and original marriage record. This follows measures that we took for birth certificates and driver's license. We altered birth certificates, as my bill called for during the last terms, and driver's license, but not marriage certificates. Marriage is an important institution, and the government should respect it for what is in reality and current context. There are all sorts of technical hurdles and identification problems when your name does not match a marriage certificate or gender identity. Because marriage records are requested documents and various things like identity checks, questions may arise should the name or gender not fit the provided document, and uncomfortable, very personal conversations may be required. And this bill also removes clerk discretion from the marriage recording changing process. As a state, Maryland has removed gender change barriers to similarly important state documents such as driver's license and birth certificates, as I said earlier. However, marriage certificate is even more important in many ways because it binds two people into one, and that union should be respected for the love that it is expressed in the current moment. So forcing someone to remain in an untrue definition of a marriage is unjustified and cruel. For these reasons, I ask a favorable report on SB 377. I'll turn it over to my witnesses now. Thank you, Mr. Chairman.
All right, thank you very much, Senator Lee. We'll now move on to your panel, and we'll start off with CP Hoffman. Welcome.
There we go. Thank you, Chair, Vice Chair, members of the committee, and thank you, Senator Lee, for introducing this bill. I'm CP Hoffman, the Policy Director at Free State Justice, Maryland's LGBTQ advocacy organization. I want to follow up on some of the things that Senator Lee mentioned in her testimony about how there is no process currently to update your marriage certificate and in Maryland, and how much it's at the discretion of the individuals who are at the county clerk's office when you go in. At most county clerk's offices, from what we've been told by clients, if you go in and you ask to update your marriage certificate, they will tell you that is impossible and there is no way you can do it. If you're lucky, they will tell you that's ordinarily impossible, but if you get a specific court order from a judge telling us we have to do it, then we'll do it. If you're extra unlucky, what they'll tell you is that you have to get divorced and get remarried in order to get a new marriage certificate. I have heard this from multiple people at multiple different courthouses. So this is not just like, something one person was told once. Like, this is something that county clerks in the state of Maryland are telling people, that they have to get divorced if they want to just change their name on their marriage certificate. Now, you might think, are marriage certificates really that important as identity documents? And yes, they are. And the reason for that is because, while you don't need them quite as often as your driver's license or passport, you do need them when you're applying for benefits, such as health insurance, state benefits, etc., where it covers both you and your spouse, or your spouse and you, as the case may be. And with the case of trans individuals especially, having a marriage certificate that lists either yours or your spouse's, or potentially both of yours, former names, that's a situation where you're potentially outing yourself or your partner to your employer, to insurance company individuals, to whomever happens to be asking for that marriage certificate at the time. And especially in the case of employers, it's creating an invitation to discriminate. So for that reason, I highly encourage this committee to support SB 377. Thank you.
Excellent. Thank you, CP. We'll now move on to Margot Quinlan. There you go.
Great. Thank you. Thank you, Chair Smith, members of the committee. Thank you, Senator Lee. We really appreciate your leadership on this issue. My name is Margot Quinlan. I'm a volunteer with Trans Maryland. We're a multiracial, multigender community power building organization for Maryland's transgender community. Trans Maryland runs the state's largest volume name and gender marker change program, and offering peer-to-peer guidance and financial assistance to Marylanders seeking a name and gender marker change. We had over 300 clients in the last 2 years alone. And as was mentioned, as identity documents are becoming increasingly easier for us to update as a community, we're hearing more and more folks are running into this barrier of not being able to update marriage certificates. We think that this barrier particularly impacts low-income married trans people who cannot hire a private attorney, kind of like CP was mentioning, to find some of these very narrow and sometimes, if you're lucky, loopholes. When requesting to update marriage documents, like was mentioned, some folks are being told, and we've heard this too, that they should get divorced and remarried. This is what I was told when I called the clerk to update my marriage license. Simply said it would match all other state, federal, financial documents, every other document that I've been able to update. I still have this one discrepancy and unable to update my name on this document, which, for us creates increased risk of discrimination for my family, including my spouse or 2 young children. And we really see this as a pretty small administrative fix that would grant us, increased access and opportunity. Ultimately, too, some of the feedback we're hearing, we really feel, especially around the suggestions and loopholes, is just an unacceptable answer on moral, on ethical, on financial grounds. Even a non-contested divorce is expensive. And so this is a simple process. We should not be having to go through these things. So we feel strongly that passing this is a simple step to increase equity and protection for transgender Marylanders. It would benefit a group of us who already face significant hurdles to being seen as our true selves. And we believe that trans Marylanders must be allowed to access the same rights and benefits as everyone else. And this bill would take us in significant steps toward that progress. So thank you again, Senator Lee. And we strongly urge a favorable report on this bill. Thank you.
Excellent. Thank you very much. All right, next we'll go to Rachel Smith. Rachel, you're up. Welcome.
Hello and welcome. Thank you so much, Chair Smith. Thank you, Senator Lee, for sponsoring SB 0377. Thank you, committee members who are here today to hear our stories. Honorable Senators, my name is Rachel Renee Smith. I live in District 44B. My pronouns are they, them, and she, her. I'm very privileged to be speaking here with you today to represent myself, my loving wife of 10 years, our 3 beautiful children, and LGBTQ families like ours. A bit about me, I came out to my wife as a transgender woman in 2016. In 2019, I obtained a court order that changed my legal name and gender. The circuit court granted my request, and the record of these changes were ordered sealed from public knowledge, or so I thought. Because I was then required to provide the court order to vital records, to change my birth certificate, our children's birth certificates, our children's elementary school and daycare facilities, to my wife's health insurance. Over the past 6 years, my wife and I changed our jobs 5 times. Each time, we had to submit the sealed court order to explain why our 2011 marriage certificate still displays my former legal name and lists my former gender as the man. With each delay, I felt afraid for the safety of my family, so I called the Baltimore City Department of Marriage Licenses. The clerk said there is no legal way to amend or issue a new marriage certificate. It's a historical document certified by the clerk of court under oath. I asked if we could get married again, and she said, no, you can only be married once, and we would need to get divorced. I explained that a birth certificate is also a historical document. The circuit court had ordered my birth certificate to be changed. The clerk recommended I call the state attorney's general's office and ask them to change our state law. Maryland law now requires transgender families to out ourselves every time that we have to show our marriage certificate. This is dangerous, and it sends the message to hardworking families like mine that Maryland is not open for business. Thank you for hearing my testimony today.
So thank you very much. Next, we will move on to is Evan Brettel here? Oh, there you are. Welcome.
Hi, thank you, Chair and the committee and Senator Lee for the opportunity to speak on this issue. My name is Evan Brettel. I am a transgender man married to a transgender woman, and my wife and I were married in 2014 prior to either of us undergoing a legal name change. So this is an issue I have personal experience with. For a married person, a marriage certificate is, as others have said, actually a personal document just as important as a passport or a social security card. And when a transgender person legally changes their name, they are often changing it not only on current ID, but on their birth certificate, because for us, that name change is not just saying, this is what I want to be called from now on, but this is who I have always been. And with those two things in mind, it is unreasonable to expect a married transgender person to live with a marriage certificate bearing a name that is neither their current legal name nor the name on their birth certificate, and that has almost no connection to that person. And my personal experience, when I legally changed my name, I spent hours on the phone and at least one full workday at the courthouse chasing down answers about how I could correct my marriage certificate. And at several points, I was told it was impossible. When I finally got the answer that I would need a separate court order, I wrote a legal petition and paid the $165 filing fee. And then even with a court order specifically ordering that my name be changed on my marriage certificate, I was met with resistance in the marriage licensing office and was still told it was impossible and had to argue repeatedly. When my wife later legally changed her name, she knew immediately that she had to file a petition, pay the $165 filing fee, and still she was again met with the same resistance and had to wait for over an hour with one of the employees in the licensing office telling her that it was impossible and trying to make her leave. My wife and I were fortunate that we had the money, the time, and the privilege to fight for our marriage certificate to be corrected, but these hurdles are absolutely not reasonable to expect. And given that steep opposition, it may as well be impossible for the vast majority of Marylanders. The initial name change court order should be sufficient to change a name on a marriage certificate as it is on any document. Thank you. I respectfully request a favorable report on Senate Bill 377. Thank you for your time.
Excellent. Thank you very much. All right, next we'll have Lee Blinder. Finally. Sorry, this is like Hollywood Squares here. I'm looking for Lee. Is Lee here?
I don't think so.
Okay, got it. All right, then that will conclude the testimony for the proponents of the bill. We'll switch over to the opposition panel now. And that is Mr. McAvoy's. Is Vince McAvoy here? All right, going once, going twice. 3 times over. Okay, great. So with that, that'll conclude the testimony for Senate Bill 377. We'll now move on to questions from the committee. Seeing no questions from the committee, that'll conclude the hearing for Senate Bill 377. Thank you, Senator Lee, and to your panelists. We'll now move on to Senate Bill 279. Senator Hettleman, you're up.
Thank you very much, Mr. Chairman, Mr. Vice Chairman, members of the committee. Senate Bill 279 allows money from the Attorney General's Consumer Protection Division to be used for the Access to Counsel and Eviction Special Fund. And what I mean by that is it enables any sort of settlement or lawsuit resources that are won by the Attorney General's office to be directed to the Access to Counsel Fund. We have precedent for doing this. For example, the legislature has directed funds from the Cigarette Restitution Fund and directed it in a purpose linked to the reason for the fund at the beginning, for health reasons, relating to tobacco, for education reasons. We do the same thing with the Opioid Restitution Fund, that revenues that are received from the state as a result of settlement with opioid manufacturers or et cetera, they are also directed to substance use programs, et cetera. So this is picking up on that precedent that we have agreed to in years past, and doing the same thing with regard to an Attorney General's settlement or judgment against a party that has been involved in unfair, abusive, or deceptive trade practices on rental residential property. I have panelists that are going to talk about why this is important. And I will also say that this body last year, in its wisdom, created the Access to Counsel program, and we did not, unfortunately, fund it. We do have a variety of mechanisms before the legislature this year, and this committee will hear some of them coming up to address the financial needs to make that program a reality. I would say, even if we find a different approach to addressing this current year's needs, which are about $12 million, the program, once it gets up and running, will require about $30 million a year to make sure that people facing eviction have the counsel, the access to counsel that they desperately need. And by enacting this bill will ensure the future stability and viability of the Access to Counsel Fund and the Access to Counsel program. So without further ado, I'd love to pass it on to my panel. Thank you.
Excellent. Thank you very much, Senator Hettleman. And we'll go on to Mr. Hill first. Welcome.
Good afternoon again, Mr. Chair, members of the committee. Again, my name is Matt Hill, attorney at Public Justice Center. We are in support of SB 279 as part of a larger plan to fully implement access to counsel and evictions legislation. As Senator Hettleman said, this is one of a couple different funding mechanism bills, and we appreciate the committee's time. I want to be clear that we don't believe that the bill is sufficient by itself to be a consistent source of funding year after year, but as part of a broader funding plan, this would be an important component. And I just want to come back to a key passage from that bill, which this committee, which last year's bill, which created the Access to Counsel and Evictions legislation. And that is that the legislation says that limited income tenants in eviction cases shall have access to legal representation as provided in the subtitle. It's not going to be optional. The state has committed to making this happen in the next 5 years. and next 4 years, now the next 3 years, really. And so this is an important opportunity to move that process forward. As Senator Hedelman said, the task force that met repeatedly in the last 2 months of 2021 found that 11.8 million would be needed to implement this in the first year. And we fully urge the committee to make sure that 11.8 million is allocated for FY 2023. We estimated this would help 9,762 Maryland families avoid disruptive displacement in eviction cases. I want to emphasize that there are still 105,000 Maryland households who are behind on the rent and facing eviction in the wake of COVID-19, the vast majority of whom are persons of color and are households with children. Council is one study in the Maryland jurisdiction found 92% effective in preventing the disruptive displacement of families in eviction cases. What do I mean by that? I mean that either preventing the eviction, getting the property repaired so that people can live there in a habitable home, or helping them transition into a new place if that's what they want to do. So I'll stop there. I have plenty more to say, but I will stop. Thank you.
Excellent. All right. Thank you very much. All right, we'll now move on to Ms. Seltzer. Welcome.
Thank you, Mr. Chair, Mr. Vice Chair, and members of the committee. My name is Deb Seltzer. I'm the Executive Director of Maryland Legal Services Corporation. MLSC was created by the Maryland General Assembly in 1982. And since that time, we have helped fund legal services for millions of low-income Marylanders. And last year, we were named the administrator of the Access to Counsel program that passed the legislature. From our grantees reporting, we know that behind family law, housing represents the greatest need for low-income Marylanders looking for legal services. And the General Assembly obviously took a great step towards meeting that need by passing the Access to Counsel program. And while funding has not yet been available, so legal services under this particular program have not started, MLSC has used special funding to award eviction prevention grants. So last fiscal year, 2021, MLSC grantees helped more than 800 clients and their families avoid evictions. And these were families facing evictions in spite of various federal and state moratoria. Those 800 clients were on top of thousands more who received advice, got help negotiating with their landlords outside of court, or achieved some other benefit. A stable funding source for the Access to Counsel program must be identified so that all eligible tenants have the benefit of a lawyer. Funding raised through this bill could offer an important supplement to another ongoing funding source and will make a tremendous difference for Maryland's low-income tenants. Finally, I'll note that I served as chair of the funding committee of the Access to Counsel task force, and we thank Senator Hedelman for her participation on that committee. Both the committee and the full task force supported the concept of this bill when it was introduced to us last year. So thank you for the opportunity to be here, and MLSC asks for a favorable report on Senate Bill 279.
Thank you for your testimony. We'll next move to Katie Davis.
Good afternoon, and thank you for being here today and for giving me the opportunity to testify. I'm Katie Davis. I'm the director of the Pro Bono Resource Center's Courtroom Advocacy Project. Since 2017, we've been providing day of court representation for tenants in rent court. We currently have 6 staff attorneys plus volunteers representing tenants 5 days a week in Baltimore City and Baltimore County and staffing a tenant hotline. Even with this increased staff and growing volunteer base, we estimate that we can reach far less than a third of the tenants who appear in court in Baltimore County alone. For those clients we're able to represent, the benefits are clear. Over 76% of the clients in FY21 either avoided an eviction entirely or were granted a postponement delaying their eviction based upon a valid defense asserted in court. For some, we identified and presented valid escrow claims based on dangers in their home to their life, safety, or health. We worked with clients living without heat or water, trying to keep children safe in a home riddled with mold. For other clients, we were able to challenge the landlord's ledger or lack thereof, or rental license or registration. For numerous others, our attorneys negotiated postponements based on the availability of rental assistance funds through which landlords recovered months of overdue rent. None of these outcomes would have been possible without access to counsel, And in each case, a tenant or family was able to stay housed as a direct result of their legal representation. In a state where 90% of landlords are represented in court and 92% of tenants are not, access to counsel for tenants is vital to level the playing field and keep deserving tenants in their homes. So as you've heard, last year's access to counsel and evictions legislation mandates that all limited income tenants in eviction cases shall have access to legal representation. While we agree that Senate Bill 279 is not sufficient by itself to provide a consistent source of funding for this legislation, it would be an important part of the comprehensive plan. It simply ensures that penalties assessed against predatory landlords would in part be directed to the fund. It doesn't alter existing law to increase these penalties, nor does it impose any additional burden on the courts. As stated in the preamble to the bill itself, Maryland already permits penalties assessed against other bad actors to be directed to funds meant to ameliorate, thank you, the consequences of these actions. It's logical that this pattern would continue, and we ask for a favorable report for Senate Bill 279 so that can happen. Thank you.
Thanks, Ms. Davis. Ms. Hatfield.
Thank you very much. Good afternoon, members of the committee. My name is Carissa Hatfield, and I am a staff attorney with the Homeless Persons Representation Project, which has offices in Baltimore City, Prince George's, and Montgomery counties. We serve tenants in landlord-tenant proceedings and have done so before the pandemic and continue to do so every day. I don't want to take up too much of your time since my colleagues at the bar have said so aptly the reasons why Senate Bill 279 is necessary. I do want to point out while I'm with you all that access to counsel ultimately saves the state up to $62 million in reduced emergency room, emergency shelter, and foster care costs. And while this bill may seem like it costs money, it's actually ultimately going to save the state money and provide a great benefit to tenants. I appreciate your time on this, and I look forward to hearing any questions from the panel. Thank you, and we support Senate Bill 279.
Thank you so much. Ms. Fulham, you are next.
Hello, thank you. My name is Nicole Fulham, and I'm a student attorney in the Public Health Law Clinic at the University of Maryland School of Law. Today, I'm here in support of SB 279 for 3 reasons. First, eviction defense is an effective public health measure. Second, providing access to counsel is proven to prevent disruptive displacement. And to be clear, these evictions that are being prevented are evictions where tenants have valid defenses. And lastly, SB 279 is critical to helping Maryland effectuate the access to counsel in eviction proceedings. When thinking about funding this program, it is important to remember why the Access to Counsel bill was passed last year. First, eviction defense is an effective public health measure, and evictions have long-lasting and significant impacts on individuals in all aspects of their lives. In addition, an eviction record makes it more difficult for some of the most vulnerable individuals in our communities to find subsequent housing and jobs. Second, providing access to counsel is reducing eviction rates. Without legal representation, tenants are often less prepared and unaware of the valid defenses that they may have. Even when eviction is warranted, attorneys are able to mitigate the impacts by helping tenants negotiate a payment plan or subsequent move-out dates. Therefore, it is critical to ensure that the Access to Counsel program is fully implemented. Finally, SB 279 is necessary for this program. The need for legal services in Maryland has only grown, and this is one way to supplement other potential funding sources and create a new funding source. Access to counsel for tenants was a priority last year, and it is critical to ensure the program is successful by seeking all viable sources of funding. For these reasons and all the other reasons discussed, I encourage a favorable report on SB 279. Thank you so much for your time.
Thank you, Ms. Fulham. Next, we'll go to Shaprice Shears Motley. I apologize if I mispronounced that. Ms. Motley, you're up. So I don't know if it's just me that is slowed down here.
Can you hear me now?
I can hear you now. Please go ahead.
All right. Hello, everyone. Good afternoon. My name is Shaprice Motley. I'm a social worker as an outreach manager for a nonprofit agency in Baltimore County known as CAN, Community Assistance Network. My day-to-day work consists of not only supporting my staff as they juggle the increasing calls for eviction prevention, but also the advocacy for the individuals and families who are facing the eviction. When it comes to eviction, tenants are set up to fail. In eviction lawsuits nationwide, an estimated of 90% of the landlords have legal representation, while only 10% of the tenants are afforded that same opportunity. Without representation, the majority of tenants doesn't have a fighting chance and are ultimately evicted. We know that this alone can have devastating consequences for individuals, communities, and the availability of affordable rental homes. On any given month pre-pandemic statewide, there was an estimated of 55,000 stay-to-pay notices filed in court. Last year in Baltimore County alone, CAN was able to assist at least 661 families stay in their homes and with referrals to legal representation. I, who also come from a place of understanding what it was like as a child and my family not having the legal representation to aid in the never-ending cycle of homelessness. In support of the Senate Bill 279, we are able to refer the basic right, for example, a mom of two who can service who was evicted from her home because she simply didn't understand the process, but ultimately was referred to legal services to regain housing most recently. Or the senior who entered our shelter that suffers from a mental illness and does not have the capabilities to understand the 15-minute fast-paced eviction court proceedings. So I ask that you consider this bill, as it is important not only to the people it will represent, but also to the communities throughout Maryland and, to service and become a better Maryland. Thank you.
Thank you so much for your testimony. Next on the list here, we have Matt Peterson. I don't see Mr. Peterson in the Zoom room. We'll come back to Mr. Peterson if he arrives. Faye Smith. I don't see Ms. Smith in the room either. Donna Whitaker. I don't see Donna with us. I did see Mr. Wiggins, who is next. Mr. Wiggins, please go ahead.
Good afternoon, Mr. Chair and members of the committee. Grayson Wiggins on behalf of the Maryland Multi-Housing Association. We are favorable with amendments. You have our written testimony. We certainly feel that this is a better funding method than unrecoverable fines being placed on housing providers for simply going seeing a judge. Our amendment is pretty minor. I think it just puts the word final before the term settlement, agreement, and judgment to clarify that the process would need to be exhausted before funds are allocated. I would also be remiss if I didn't tell you that it's not lost on us that on page 2, line 28 of the bill, the Attorney General's office can recover the cost of bringing the action. And with that, I would take any questions.
Thank you, Mr. Wiggins. That concludes the testimony for the proponents of the bill. Senator West, did you still have a question? I noticed your hand was up earlier, but is no longer up.
Actually, I did have a very modest question, and I don't like this is for the sponsor of the bill. I don't like preambles in the first place. But in this particular preamble, you've got a whereas clause that specifically refers to the details of an ongoing piece of litigation and names the litigants. And would you have any objection to taking that out of the bill? I just don't think that's a good practice for us to get into.
I don't have any objection to that. If this is, if there seems to be consensus, I don't have an objection to that.
Well, I love the bill. I just don't like the preamble.
Objection sustained. I always wanted to say that. Signed up next for informational purposes is Nicole Hansen Mundell. Ms. Mundell, you're up.
Trying to unmute myself. Hi, good afternoon. Nicole Hansen Mundell, Executive Director of Out for Justice, a grassroots-based org that is led by formerly and currently incarcerated people And of course, it is the members of this organization who is most impacted by not having access to counsel. Unfortunately, fortunately, we have some help this year with some policy folks. And so I should have been signed up to be in support as opposed to just informational. But I echo all of the statements of my colleagues. The only thing that I would note is that this would be crucially important. It's specifically because we know kind of Maryland ranks 8 in the nation for the highest hourly wage required for rent of a 2-bedroom apartment as $28.06 an hour you would have to make in order to afford housing here in Maryland. And that's just according to the National Low Income Housing Coalition. But more certain, moreover, even in places like Montgomery County, you would have to make $33 an hour to be able to afford a 2-bedroom apartment, right? And so individuals need right to counsel across the board, whether it's family law, civil law. But since we're here in terms of housing, let's do it. Let's do the right thing. We know that this is happening all over the nation right now. As of mid-June, legislators in Massachusetts, New Jersey, and Delaware are having these type of conversations and enacting rights to counsel bills. Mr. John Pullock, coordinator of the National Coalition of Civil Rights to Counsel, he says that in many cases, these bills build up like this has on the right to counsel programs and that have been passed already in New York and 9 other major American cities. So we're on the right track, right? And so it is time that Maryland just does the right thing and get in line with the rest of the nation on this. Thank you.
Thank you for your testimony. Questions for Ms. Hanson-Mundell? Seeing none, that concludes the hearing for Senate Bill 279. We'll stay with you, Senator Hedelman. You're up with
Mr.
Senate
Vice
Bill.
Chair, sorry, Mr. Peterson has just arrived.
I understand. Matt Peterson, I'm going to ask you to unmute, and if you can just click that button on your screen, we are good to go.
Hi, thank you so much. Sorry that I'm late. Appreciate your accommodation here, but I just want to add on to what we've heard from others. I'm here on behalf of the Baltimore Jewish Council and want to offer strong support for funding tenant access to counsel. We know how much of an aid this is to folks when they do appear in front of eviction hearings to have counsel with them. Just about 1% right now of tenants are able to, have counsel when they are in proceedings. And, here at the Baltimore Jewish Council, we represent an organization called HI, Comprehensive Housing Assistance, Inc. And they're just one of many housing assistance organizations across the state that could greatly expand their reach when working with tenants if they're able to if we know that if we are able to fully fund right to counsel. So again, we offer our strong support for this bill, and I just want to thank you again for allowing me to testify, even though I showed up a few minutes late. So thank you.
No worries. Thank you, Mr. Peterson. All right, Senator Hedelman will now move on to Senate Bill 280, interim and temporary protective orders.
Thank you so much, Mr. Vice Chair. For the record, I'm Shelley Hedelman, Senator from District 11. You all have before you Senate Bill 280, which the advocates and proponents of this legislation have been working furiously over the past number of days. And I think we've come to consensus that has mitigated some of the opposition. And so I want to go through, rather than going through what's exactly in this bill, I want to go through how we'd like to amend it. So as this committee well knows, there is a problem of intimate partner violence. And as this committee knows and has experienced directly with, we have made it easier over the past few years to file things electronically. There are people who are seeking care in a hospital setting who would like to get a protection order, a temporary protection order, while they're in that hospital setting. It might be that they're going there because they have they need medical care for an injury that they have sustained because of intimate partner violence, but they may be there for other reasons. We do know that people often feel most comfortable disclosing the details of being a survivor with with their doctors or with their nurses or in a safe place. And many people, and you'll hear from some of our panelists, how some of the clients that they work with feel safe in a hospital setting. So the bill would be amended to just include hospitals, not urgent care centers. We would also expand it to include domestic violence programs that are community-based programs that are providing services to survivors of domestic violence. So someone could be in a hospital setting, but they could also go, for example, to the House of Ruth, or they could go to another program in the community that serves survivors of domestic violence, and they can file an electronic temporary protection order. If they are going or in a hospital where there is a domestic violence program situated there, I know of two that are near me, one Sinai Hospital, and you might hear from folks from the Center for Hope, which is an advocacy organization that is hospital-based, that serves victims of child abuse, elder abuse, and intimate partner violence, or for example, the Dove program, which is at Northwest Hospital. If you are in a hospital seeking care there and wanting to file an electronic protection order, the hospital you will have the help of the advocates that work, or the personnel who work with that domestic violence, help you file that electronically. If you are at a hospital where there is not a domestic violence-based program, you will be connected with the community-based program that is there to help you through the filing. I have spoken directly with Judge Morrissey, and we have crafted amendments, and he has withdrawn the opposition of the judiciary. So I wanted to share that with the committee. I am happy to answer any questions, and I want to let others on my panel talk to you more directly and in more detail about why this is important. And you will hear some stories about people going to hospital settings for whom this is very important, and provides safety for people who, so that they don't have to go down to the courthouse. This is an ex parte proceeding anyway. They will have to go in 7 days, but at this particular point for the ex parte piece, we believe that, and this is being done in other places, in other states, that this is a streamlined and efficient and safe and fair way for someone to get a protection order today. So without further ado, I will pass it on to the next witness. Thank you.
I see. It looks like the chairman may need to be made host. So we'll move on to Sarah Mikey while that gets done. Ms. Mikey.
Good afternoon, Chair Smith and members of the committee. I'm Sarah Mirsky-Mickey, Deputy Director of the Baltimore Jewish Council, which represents the Associated Jewish Federation of Baltimore and all of its agencies. First, I want to say how proud I am of the amended bill presented today. I want to thank the judiciary for withdrawing its opposition, and to the organizations that were favorable with amendments who also now support this version. SB 280 comes from issues I was told about of clients leaving the safety of a hospital without any protection from their abusers. So if a victim is in the ER in Maryland and is screened as they are supposed to be for violence, discloses the violence, what can a hospital do now? While some hospitals may connect them to a program or may have a hospital-based program, a social worker, or a forensic nurse, they cannot ensure the safety of a victim when they leave the hospital. In fact, their abuser could be in the waiting room or the car. Further, as you know, violence is not ever only physical. It can be emotional, financial, and technological. Many domestic violence victims are electronically tracked by their partners, making it very dangerous to drive to a courthouse. But a hospital or a victim service organization can be a safe place. This bill is simply about expanded access to safety and justice for violence victims. When I began working on this bill, I contacted Melanie and Senator Hettleman and began researching different states to see if they had any solutions. New Jersey has had a hospital-based program for over 10 years where victims can file and have their protective order hearings in the hospital. Several states over the summer were considering similar and even more expansive legislation, and many, like Washington State and California, have now passed laws allowing for a similar electronic filings and hearings, whether it's at the hospital or a victim service program. This bill, as we have amended it, only allows for temporary protective orders, which are ex parte hearings, to be virtual from a hospital, domestic violence, sexual assault, vulnerable older adult, or child abuse program. The final protective order hearing would still be in person. Maryland courts have been for almost 2 years conducting both civil and criminal proceedings virtually. We have the technology. Now let's use the technology for good and help victims of violence have more access to safety. For these reasons, we ask for a favorable report on SB 280. Thank you.
All right, I think I've got the privileges back. Thank you, Vice Chair Wallstreicher, and thank you, Ms. Mickey. Good to see you. All right, we'll now move on to Ms. Shapiro.
Good afternoon, Mr. Chairman, Mr. Vice Chair, members of the committee. Melanie Shapiro, Public Policy Director with the Maryland Network Against Domestic Violence. When the pandemic hit, we all switched to platforms such as Skype, Zoom, and WebEx to perform our jobs. Court buildings closed and proceedings went online. But even before the pandemic, courts in Maryland conducted remote proceedings such as bail reviews. Rules already existed regarding the use of video conferencing in certain criminal and civil court matters. Also during the pandemic, both child abuse cases and domestic violence cases got more severe. We have examples of New York, New Jersey, North Carolina, West Virginia, Indiana, California, Minnesota, and Washington, D.C., just to name a few of the states that have improved access to courts and safety for victims of abuse by implementing a process that allows a petition to be filed electronically and hearings to be held virtually. Each process looks a little different. In some states, anyone can petition electronically, and in other states, it must be done by a program or an advocate. Senate Bill 280 would allow anyone eligible for protective order to file a temporary protective order petition electronically from a hospital, domestic violence, sexual assault, or human trafficking program, child advocacy center, or program for vulnerable adults, and have the temporary hearings heard virtually. It is intentionally limited to what is already ex parte hearings and does not extend to the final protective order hearing. The bill is also enabling to hospitals and not a requirement. For example, some hospitals, approximately 12, have hospital-based domestic violence programs, but not every hospital is so fortunate. Hospitals are a critical point of identification and intervention for victims of abuse, including child abuse, vulnerable adult abuse, as well as sexual assault and domestic violence. We must prioritize the safety of victims and improve access to courts. There are numerous barriers to accessing courts, including an abuser that may be stalking a victim and tracks them going to a courthouse, someone unable to leave the hospital bed to get to the courts, or someone showing up at a shelter with nothing but the clothes they are wearing. There's also the very real barrier of transportation, as you will read in some of the written testimony, especially from one of our more rural counties. And we can't forget that leaving an abusive relationship is one of, if not the most dangerous time for a victim of domestic violence. We must do better. We have the technology, the rules exist. We must remove the unnecessary barriers constructed and allow victims better court access. I would like all of the partners who come together to work to amend this bill to get to a point where the judiciary and all the programs are in agreement, and thank Senator Hettleman for her leadership. We urge a favorable report on Senate Bill 280.
So thank you very much, Ms. Shapiro. Now hear from Ms. Watts.
Good afternoon, Mr. Chairman, Vice Chairman, and other committee members. My name is Lydia Watts, and I am the Executive Director of the Rebuild, Overcome, and Rise, or ROAR Center at the University of Maryland, Baltimore. ROAR provides services to victims of all types of crime and violence in Baltimore City specifically, with a full range of wraparound supportive services, including legal, therapy, case management, and nurse care management all in one place. I also am testifying in support of Senate Bill 280. My written testimony has details of 3 specific clients for whom this access would have greatly reduced their risk of harm. One had been shot by, this was actually pre-pandemic, she had been shot by her intimate partner who was still at large. She was in the hospital recovering from the gunshot wound. My attorney did go to the hospital to meet with her, not my attorney, my staff attorney, she's not mine, and did urge both the commissioner's office, and then ultimately went to a judge in Baltimore City to get permission for the client to be able to petition for a temporary order from the hospital bed. It was obviously very critical to her safety, given that the person who had literally put her life in very grave danger by shooting her, she was able to get that additional protection before being discharged from the hospital. The other two examples are both during the pandemic. One was about a client that was stalked by her abusive partner that she had separated from at the commissioner's office when my staff attorney was there with the client trying to petition for a temporary protection order. So had that client been able to petition from our offices, that would have eliminated that risk of, which actually did come to fruition, where her abuser was there kind of racing her to the commissioner's office and placing both the client and quite candidly my staff attorney at fear when they arrived and he was in line waiting to enter. This is when there was still very long lines to get screened into. It was very early in the pandemic. A third is also an example of a client that was being very severely stalked by her ex-partner and led this survivor to be so fearful for her safety that she was too afraid to return to court. In that case, it wasn't an initial petition, it would have been a renewal, but nonetheless, I share that as an experience of a survivor and why going to a location that is known to an abusive partner who is intent on finding the person that they are causing harm to can put somebody in quite a bit of danger. I will just add that prior to practicing in Baltimore City, I practiced in Washington, D.C. for over 20 years. And in DC, we implemented a similar process at Greater Southeast Community, well, what was then Greater Southeast Community Hospital is now United Medical. And I believe it was 2003 or 2004. So this was using old school webcams and fax machines. But again, the imperative at that point was really not only safety, but also to reduce barriers to survivors having to return to court only days later, when in many
Ms. Watts,
instances,
your time is a little over. If you could briefly conclude.
So I just urge you I will just conclude there. Thank you very much.
Thank you very much. Thank you. Okay, great. We'll now move on to Mr. Rosenberg.
Good afternoon, members of the committee, Mr. Chairman, Mr. Vice Chair, Senator Hedelman. Thank you for sponsoring Senate Bill 280. My name is Adam Rosenberg. I am the Vice President for Violence Intervention and Prevention at LifeBridge Health and the Executive Director of our Center for Hope, which is formerly known as Baltimore Child Abuse Center. We are in the unique position of actually having both the hospital perspective, seeing these patients directly in our emergency departments, as well as having multiple hospital-based programs and violence prevention programs within our Center for Hope orbit there, domestic violence, human trafficking, child advocacy center, and elder abuse responses there. We are testifying in support of Senate Bill 280, as our programs help thousands of these survivors each year, and many of these survivors are living in your very district that we're providing services from our Baltimore Child Abuse Center, our Dove program, our Sinai Hospital, our Grace Medical Center, our Northwest and Carroll hospitals as well there. We very much unfortunately know firsthand the fear and the trauma that many of these survivors of violence face in those first moments when they find themselves either in a hospital or in one of our programs, confronted with the very stark reality that there are a few things that they can do immediately to protect themselves, and access to that emergency order matters greatly. As has been said, both in my written testimony and my colleagues on the panel here, this platform opens up a world of possibilities to increase safety and access to safety for just thousands and thousands of victims of all ages and all circumstances each year. And the same technology should be available for our survivors of violence, rather than having to make them still go through what is unfortunately an antiquated process at this point, when we have this technology that is used in bail hearings and in committee hearings as well. I certainly encourage you to see our testimony as well, and to draw upon the other experiences there. And we encourage a favorable report in Senate Bill 280. Thank you very much.
So thank you very much, Mr. Rosenberg. We'll now go on to Ms. Emerson.
Wasn't letting me unmute. I'm sorry.
There you go.
Good afternoon, Mr. Chairman, Mr. Vice Chair, members of the committee. My name is Jessica Emerson, and I direct the Human Trafficking Prevention Project, which works to reduce the collateral consequences of criminal legal involvement for survivors of human trafficking and those populations put at highest risk. I'm also here in support of SB 280 with the sponsor amendments. While the conversation pertaining to protective orders understandably centers around victims of interpersonal violence, it's important to remember that IPV commonly overlaps with human trafficking. It's not uncommon for a victim's spouse or romantic partner to be their trafficker, subjecting them to forced prostitution or other forms of labor. The growing recognition of the connection between these two crimes is crucial as we as service providers work to assist survivors in obtaining justice. Given the level of physical and psychological abuse that survivors of trafficking face, it's not surprising that 88% of human trafficking victims access healthcare at some point during their trafficking situation. This frequency of use suggests that meaningful interventions can indeed be made in the hospital setting. And given that many hospital-based domestic violence programs already exist in Maryland, and that there is a concerted effort through the Mercy Forensic Nursing Program to develop similar protocols for human trafficking, hospitals are indeed well suited to provide this additional supportive services to DV victims seeking temporary protective orders, including those who have been trafficked. Additionally, given that victims of trafficking are commonly also victims of sexual assault, domestic violence, or child abuse, and may be receiving services at organizations supporting survivors of any one of these crimes, it's crucial to their safety that they be able to petition for a protective order in a setting where they're likely already comfortable and receiving support. Courts in Maryland have successfully conducted virtual hearings throughout the course of this nearly that was a Freudian slip, 2-year-long COVID-19 pandemic. It should no longer be necessary to require a victim of violence to potentially undermine their physical or emotional safety by leaving the security of a hospital or other safe organizational setting to obtain a temporary protective order. For these reasons, the HTPP supports Senate Bill 280, respectfully urge a favorable report, and thanks Senator Hedelman for her leadership in sponsoring this bill. Thank you.
Thanks, Ms. Emerson. All right, next we'll go on to Ms. Rodriguez.
Thank you so much. My name is Amanda Rodriguez. Mr. Chairman, Mr. Vice Chair, members of the committee, I am testifying in support of SB 280. I am the chair of the Maryland Trafficking Task Force's Legislative Committee and also the Executive Director of Turnaround, which is the Rape Crisis Center, a comprehensive domestic violence provider and comprehensive anti-trafficking provider in Baltimore County and Baltimore City. During the beginning stages of COVID, just like everyone else, we decided to move everything online. And the reality is we were able to continue to provide services even through the darkest days of the pandemic. And it's imperative that we utilize this technology that we were able to use to ensure that services remain as accessible as they possibly can to survivors of violence. I have 2 quick examples of how this would have impacted turnaround survivors, those that utilize services with us. The first is there was a survivor who was badly injured, was placed in the hospital. She actually had multiple broken bones and could not access a protective order because of the condition of her physical body. It took her weeks to get out of the hospital, and by the time she did, her abuser had reconnected with her, and ultimately she did not have the safety of a protective order. The other, actually, I worked with the survivor directly myself. In this case, because we are a nonprofit that sometimes runs on a shoestring budget, I was actually the one answering the helpline on a Friday evening. And so I did that and spent about 3 hours on the phone with a survivor at a hospital and also her social worker. We worked out a safety plan and everything that she needed to get out of that situation. And the plan was that she was going to remain in the hospital until Monday, when she would come to Turnaround and start accessing services with us. During that weekend, because we were unable to get a protective order or anything else to keep her trafficker away, he found her, took her out of the hospital on Sunday, and ultimately there was a body matching her description that was found 2 days later. For the foregoing reasons, we ask that there is a favorable report for SB 280. It is really an imperative kind of next step to make sure that we can keep survivors safe. Thank you so much.
Thank you, Ms. Rodriguez. It's good to see you as always. Ms. Lennick, you're next.
Good afternoon, Mr. Chairman, Mr. Vice Chairman,
My name is Dorothy Lenig. I'm the director of the legal clinic at the House of Ruth. The House of Ruth serves victims of domestic violence throughout the state. First and foremost, I want to thank the sponsor, not only for introducing this bill, but for working with all the advocates to come up with what I think is a great bill. House of Ruth is 100% behind it for all the reasons that people have expressed. So in the interest of time, I urge a favorable report. Thank you.
Well, we definitely like some Me-Toos here. Thank you, Ms. Lenig. Ms. Ruth, you're next.
Good afternoon, Mr. Chair, Mr. Vice Chair, members of the committee. My name is Lori Ruth. I'm the legal director at the Women's Law Center of Maryland. I also want to thank the sponsor. I especially want to give my thanks to Ms. Shapiro and Ms. Mickey, who were amenable to listening to some of the concerns. When we originally came in favorable with amendments. On the House side, they made some of those amendments, but we thought there was further work that had to be done. And they worked really, really hard to make what I think now is a stronger bill than the original bill that we fully support as amended by Senator Hettleman. And, you know, the added benefit of having the judiciary come off their opposition is a really, really good thing. So I will also not belabor things. I will just say thank you so much for all the hard work that was done and for listening. And we urge a favorable report as amended on Senate Bill 280. Thank you.
Thank you, Ms. Ruth. That concludes the testimony for the proponents. We'll now take questions from the committee. Senator Casserly.
Thank you. This is one of those where you totally support the goals, and unfortunately the amendments are sort of the dispositive thing here, and the judiciary amendments, we don't have those. But my only question, Senator Hettleman, excuse me, mouthful, is whether those amendments with the final hearing, do they provide for in-person or only video? How does that work?
Could be in person. You have to go. Yeah.
Gotcha. Okay. Thank you. That's all I have. Thanks.
Thank you, Senator Casserly. Senator Carter.
Thank you, Mr. Vice Chair. Thank you for the testimony. I apologize. I had to slip out and take a quick meeting. I'm really sorry about that. So I might have missed some answers, but my question stems back to your original testimony, Senator Hettleman. You mentioned that the judiciary had come off of the opposition. I had read they're unfavorable, and they had two primary concerns. They were concerned about the ability to assess the credibility of a witness through this process, and they were also concerned about taking away discretion. And so I really do apologize if I missed this, but that was a question that I had too, because there is currently the discretion to do it. And so have there been specific situations where a court has said, nope, can't do it, won't do it?
So I don't know of specific instances. Some of the advocates here might, but I can tell you, I had conversations with Judge Morrissey, and he has withdrawn his opposition. And I think part of the concern, and Dorothy, Ms. Lenig might be able to shed some light on Montgomery County, their Family Violence Center has been doing this. So the practical implications have been overcome there. And I think that he has seen it work there. You have the second part of the hearing to be able to see and to be able to assess in person. So I think that's where some of those concerns can be addressed.
So again, I guess we have to see, I mean, if he withdrew the opposition, there must be something in those amendments that fixes those two concerns. And so I too, I'm just curious to know what the compromise was.
I am happy when we go through, sit down and go through it. I'm happy to get it to you before then, certainly. But actually, Ms. Lenig, could you, Mr. Chairman, if that would be okay for her to address?
I think part of his concern, and I don't want to speak for him, but some of the things he expressed to me was doing it at the interim with nobody there helping the person. And so once the idea was to link the survivor to either a hospital-based program or a community-based program, then he had more assurance that there wasn't somebody forcing the petitioner to file it and that she or he were acting on their own. And so when somebody's in court in front of you, you can assess that better. So I think that gave him some confidence And then just process wise, the whole thing, I think, just flows a lot better this way in his mind. So
yeah, the other thing I would add is in terms of, I think he was a little concerned about a petitioner doing it themselves, and pairing with an advocate gave him, I think, again, I don't want to put words in his mouth, but he expressed confidence that people who do this on a regular basis would be able to help support somebody who was, in a vulnerable situation to be able to complete the paperwork adequately.
Actually, I probably have the opposite concern. I feel like people do them on their own all the time. And like when they go to the commissioner, I've been there, and the commissioners will tell them specifically, I can't tell you what to say. You just have to tell me the facts and I can assess it based on what you say. And so I have the opposite concern because I would not want someone like actually doing it for someone. That's
not doing it for somebody. It is helping them do it. Absolutely not doing it for somebody.
Okay, thank you.
But that was a concern he had expressed to me.
Thank you.
All right. Thank you for the questions. We'll now go to the unfavorable testimony. Mr. McAvoy. There you are, Mr. McAvoy. Please go ahead.
All right. Thank you so much, committee. I appreciate that. I understand that Judge Morrissey's removed the opposition. That's not the same as support. I haven't seen the amendments, nor have I seen the latest protocols where COVID intersects with the preventing potential offenders from entering hospitals. And that could be a helpful thing. But the bill should be limited to the stated purpose of the bill, which is hospital or urgent care. The concern arises when I'm hearing testimony where thousands can be helped, I'm hearing, but in the vast amount of cases in Maryland, there is no physical symptoms, no injuries. So I want to mesh some of my original thoughts, given the fact that we are looking at amendments and tinkering with this. And House testimony I've given in previous years, I reference workers at the Calvert Street courthouse, and they refer to the deluge of false allegations made about domestic violence on Calvert Street, to the point where they've given them a nickname, which we don't repeat on the air because it's ungentlemanly. But I see that there is an abuse of this process as it stands right now, and I think this will invite additional abuse. For that reason, I'm against this bill. I think that there's just very few cases where we would actually need this. And it's not a matter of offering technology. There's a due process issue. I've actually been in the courthouse on North Avenue where House of Ruth attempted to enter the first ex parte without a plaintiff. This is pre-COVID. You need we have due process issues. So I'm sure Judge Morrissey knows that. I'm positive he's reviewing that. But the potential for abuse is why I'm against this bill. I thank you for your time and listening.
Thank you so much, Mr. McAvoy. Questions from Mr. McAvoy? Seeing none, that concludes the hearing on that bill. We'll now move to the final bill of the day, Senator Heddleman. We've got one more here, Senate Bill 315, SLAPP suits. Senator Heddleman.
Thank you very much, Mr. Vice Chair, members of the committee. For the record, I'm Shelley Heddleman, Senator from District 11 in Baltimore County, and I am here to present Senate Bill 315. And this committee has heard this bill for a couple of years. It's in a slightly different fashion this year, and I want to talk about what SLAPP suits are. So SLAPP suits, in addition to having kind of a cool name, are a strategic lawsuit against public participation. It is a meritless lawsuit intended to shut down free speech. They're often filed as defamation suits, but they can be disguised as anything from breach of contract to an interference with some economic benefit. What they are used to do is to intimidate and to be a bully. Senate Bill 315 clarifies that our anti-SLAPP statute extends to speech beyond just before governmental entities, to include online reviews and bloggers, letters to the editor, and other venues commonly used by community members to share thoughts and ideas and to assist the community in choosing goods and services in the marketplace. This bill makes 3 very important improvements to our current anti-SLAPP statute. And we had one of the first in the country, and at the time it was very strong. At this point, we have been given a D grade, and many states around the country have stronger anti-SLAPP statutes than we do now. That's why it's important for us to change and update. This bill eliminates the requirement that a plaintiff demonstrate bad faith in bringing forth the suit. This was a unique provision in our law that proved difficult and costly and almost impossible. It required difficult, extensive discovery. The current bill requires focus on a meritorious complaint. 2, it enables attorney's fees to be shifted, which creates a deterrent to a deep-pocketed plaintiff. And 3, it requires the courts to act promptly and hold discovery until there are expeditious rulings. It's important to note that none of these changes to current law would serve as a chilling effect to legitimate lawsuits. Expedited procedures would weed out meritless claims efficiently. And by requiring courts to act promptly and rule expeditiously, and by removing the bad faith requirement, defendants avoid costly discovery and other pretrial preparation, and SLAPP plaintiffs are stopped from wasting our courts' resources. Additionally, if it turns out that the anti-SLAPP motion is not granted and that the motion was intended to waste time, costs are awarded to the plaintiff. This year's bill makes explicit that communication to a government official is covered, and another clarifying section ensures that certain commercial speech does not qualify under the SLAPP statute, enabling appropriate product liability and deceptive trade suits to remain outside the SLAPP scope. We have heard, especially in the last few years, about SLAPP suits more and more. Our law is not sufficient to keep up with what's coming through the courts right now, and the proliferation of the internet and social media has made this a more compelling issue. I have a number of people who have far more expertise than I on this issue, and I would ask for your support of this legislation, and I will turn it over to the panel. Thank you.
Thank you, Senator Hedelman. We're going to go to Ms. Snyder. Ms. Snyder, you are up.
Thank you, Vice Chair and members of the committee, and thank you, Senator Hedelman, for your strong support on this issue. The Press Association, for the record, I am Rebecca Snyder, Executive Director of the Maryland, Delaware, DC Press Association. We have supported this bill for many years, I think at least since 2012, in trying to pass strengthening aspects of the anti-SLAPP statute. And as Senator Hedelman said, this does bring some needed change to Maryland's anti-SLAPP law. SLAPPs are not just an issue for the news media, and you'll hear from Paul Levy from Public Citizen more about that. But for the news media, they do stifle public debate. For citizens, they diminish civic engagement, for those seeking to make their voices heard on issues of public interest. And for news media, they present a significant burden for news organizations, both financially, which you'll hear from Jordy Wilson, who has a smaller publication. They're also a time-consuming distraction when journalists are struggling under the threat of anti-SLAPP or struggling under SLAPP suits. They burden those journalists both in money and time and diminish our ability to cover the communities we serve. So we do ask for a favorable report. This bill, in a very, very similar posture, passed the House last year, and we hope that the committee will look on it favorably. Thank you.
Thank you, Ms. Snyder. We'll now move to Mr. Levy. Mr. Levy.
Thank you. Public Citizen supports Senate Bill 315 because it provides strong support for speech on issues of public concern. We have seen anti-SLAPP statutes work effectively in other states to prevent the use of litigation to suppress speech, not based on any serious concern that the speech is actionable, but in recognition that the very cost of defending against litigation, often by people who had no financial stake in speaking, can take valuable contributions out of the marketplace of ideas, and it can chill the exercise of the right to speak freely about companies and individuals who establish a track record of filing suit. I myself have litigated motions under several state anti-SLAPP laws. I have seen the good ones work effectively to protect consumer speech, and I've seen the limitations of the weak ones. Good anti-SLAPP laws discourage plaintiffs from suing over such speech unless they have a reasonable chance of prevailing. It requires courts to take an early look at the merits of such cases, and it creates a financial incentive for lawyers in private practice to defend cases brought over free speech. And in that way, it enables people to stand up for their free speech rights. Now, because anti-SLAPP laws provide strong medicine, they should be drafted carefully to avoid impinging on the kinds of cases where consumers are pursuing economic justice. Such cases can rest on speech, as Senator Hedelman referred to. And SB 17, in our judgment, does a good job of excluding such cases from anti-SLAPP remedies. And my written testimony provides several examples of SLAPPs in practice, and I expect to send more to the committee. But I also want to expand before I close on something that I said at the end of my testimony. Anti-SLAPP laws should be bipartisan laws. Anti-SLAPP laws do not empower liberals over conservatives. I myself have defended conservatives in litigation protecting their free speech rights where anti-SLAPP laws would have been helpful to them. And many leading conservatives support anti-SLAPP legislation, including, as I point out in my written testimony, the General Counsel of the National Right to Life Committee. My time is expiring, but I invite questions about the opposition testimony because I've looked carefully at what they had to say in writing. And I think I have some interesting observations to make if questions are asked.
Mr. Levy will next move to Jordy Wilson. Mr. Wilson.
Thank you, Mr. Vice Chairman, Senator Hedelman, and members of the committee. Thank you for having me here today. My name, for the record, is Jordy Wilson. I am the publisher of the Frederick News Post, the daily newspaper serving beautiful Frederick, which you see behind me, and Frederick County. And I am here today to ask you to support SB 315 to help stop abusive lawsuits from being used to threaten news reporting and to stifle public debate. These kind of spurious legal challenges can be a real burden on news organizations. Defending against even completely frivolous lawsuits can easily cost tens of thousands of dollars, and battling them takes our reporters and our editors away from their vital work. This burden can be especially difficult to bear for smaller news organizations and the kinds of new journalism outlets, mostly online and mostly quite small, that are springing up to meet community needs. They don't have the kind of money to defend against these suits, and that makes even the threat of a lawsuit a powerful deterrent from covering difficult stories. In my written testimony, I referred to one egregious example that we faced a few years ago when we reported straight from a police blotter report the location of an incident in downtown Frederick, noting the landmark that was cited in the report, and it cost us nearly $10,000 to have a challenge to our reporting dismissed. We're not looking for a free pass. When newspapers and other outlets, journalistic outlets, make mistakes and harm people, we should be held accountable. But the courts shouldn't be weaponized to silence legitimate inquiry. I believe this bill strikes a reasonable balance by clarifying anti-SLAPP definitions and procedures and providing for a timely motion on the merits. I urge your support, and I thank you very much for this opportunity to speak.
Thank you, Mr. Wilson. I will now move to James McLaughlin from the Washington Post. Mr. McLaughlin.
Thank you, Vice Chair, Chairman, and members of the committee. I'm James McLaughlin of the Washington Post. You have my written testimony, and I think most of you probably at this point have heard me make a pitch for versions of this bill in past years, so I will keep it brief, but I do want to emphasize 3 points of context that I think are extremely important and sometimes get lost in the debate over this legislation. First, SB 315 would put Maryland into the mainstream of state anti-SLAPP laws. It's not some hyper-aggressive or radical proposal. There are currently 31 states plus the District of Columbia that have anti-SLAPP laws. And I'd encourage the committee members to just take 3 minutes at some point to go to the Public Participation Project website and look at their survey of the features of those state laws. And you'll see why Maryland's current law was graded a D, as Senator Hedelman mentioned in her testimony. This bill would fix the most glaring flaws, and it would put it into accordance with the bulk of state anti-SLAPP laws. Second, anti-SLAPP laws have nothing to do with political or partisan affiliation. They protect the speech of conservatives and liberals alike, as Mr. Levy mentioned. They're supported broadly by conservative speakers as well as liberal ones, and they've been used in many cases by right-wing, right-of-center publications. One of the leading DC anti-SLAPP cases is Michael Mann versus the National Review. That's Michael Mann, the climate scientist, not the documentary filmmaker. But that case has been going on for years, and the National Review has asserted publicly and has been supported by most news organizations, including ours, that that's the kind of case that should be weeded out by strong anti-SLAPP laws, and they see it as a case that's designed to punish them for publishing work in an opinion piece that's critical of Mr. Mann's research. Ultimately, anybody who speaks on a controversial issue on any side could find themselves on the wrong side of a SLAPP at some point and should welcome a fulsome, robust statute. Third, and finally, SB 315 would not prevent meritorious lawsuits from going forward. I'd be happy to talk more about that, but in brief, any plaintiff who can show that their case has a substantial justification in law and fact will survive an anti-SLAPP motion. And if you can't make that showing, frankly, you're not going to win the case anyway. And it's saving everybody a lot of time and money to have a judge weed it out at an earlier stage. Thank you, and I'd be happy to answer any questions.
Thank you, Mr. McLaughlin. Mr. Jericho.
Thank you. Thank you. My name is Ronald Jericho. I'm testifying in support of this bill on behalf of the Maryland Association for Justice. We submitted, I'm a former circuit court judge in Anne Arundel County. I returned to practice in 2011. We have submitted a written position paper, and in there is a link to the kind of study that Mr. McLaughlin just talked about, showing all the jurisdictions across the United States that have adopted a modern anti-SLAPP bill. And we support this bill because it does, in fact, bring Maryland into a consistent position with those other states. We worked with the sponsors of this bill over the past couple of years to refine a couple of points to get it to this position it is now. And what it is to stop lawsuits that impair free speech or expression in the public interest. I was involved in this kind of litigation a couple of years ago in the District of Columbia, where I was critical of a public official, and I was the recipient of a suit which was deemed a SLAPP suit. In any event, you can see other kinds of examples if you just Google Donald Trump and SLAPP suits, because I did that, and you found he's filed defamation lawsuits, a lawsuit against CNN, and for his apprentice show, he filed lawsuits against people to stop them from being critical of the show and him. So what it is, exactly as everybody said, these suits are an attempt to stop free speech and free exchange of ideas and criticism of public officials, because those are the kind of people who file SLAPP suits. And I want to just point out one more thing. The attorney's fee was mentioned by the sponsor of the bill for a SLAPP suit that's unsuccessful, but it's a balance, because there's also a provision in the bill that says if somebody files a frivolous motion to dismiss a SLAPP suit, they can be hit with with attorney's fees. So it's a balanced bill, it's fair, and we therefore request a favorable report of the committee. Thank you.
Thank you, Judge. We appreciate your testimony. We'll now move to the final proponent, John Breen. Mr. Breen.
Yes, can you hear me, sir?
We can.
Thank you very much.
No
I'm Attorney Jack Breen. I'm joining Ron Jericho in supporting the positions supported by the Maryland Association for Justice. And I want to thank all the members of this committee and you, Mr. Chair and Mr. Vice Chair, for all the time you spend reviewing these bills, et cetera. I'm sorry about my video. I really can't even add too much to the testimony set forth by Senator Shelley Hedelman. She gave a concise summary of what my written position here was. So I'll be very brief and compliment her on what her statement was. Ultimately, the anti-SLAPP statute protects free speech, and it does it by allowing a prompt dismissal of a frivolous or claim without merit to stop that public participation. And as Mr. Jericho has pointed out, the fact that it awards attorney's fees and costs against someone filing a frivolous claim to stop public participation is itself an impediment to this type of behavior and to diminish it. And that penalty is imbalanced because if a frivolous motion to dismiss is brought, the court may apply the same penalty to the frivolous motion brought by the party to dismiss. I'll add no more to the distinguished testimony of all the guests here, and I thank you for your time and for your patience and for your many hours of work during this 90-day session. Thank you so very much.
Thank you for those kind words and the testimony. For logistical purposes, we need to go to the opposition before taking questions. So we'll now move to the opposition to the bill. First up is Chairman Zirkin. Mr. Zirkin.
Hi, can you hear me?
We can.
All right, I don't know if you can see me. I apologize. And I am, as some of you may know, oh, there we are. I'm at coaching a Park School basketball game right now, so I apologize about this, which is Senator Hedelman, my senator's children's school. So I hope you'll take that into account. But anyway, I wanted to talk about this SLAPP suit bill, and I could hear some of the proponents of it. And I want to give you a personal story. First of all, I just want to say, good to see all of you guys. Great to see all of you guys. And hope you're having a great session so far. This bill has been killed in the legislature for multiple years. And the reason is because although it is a bill that sounds like it has a very good purpose, the actual application of it can be very nefarious. And unfortunately, I actually have a very personal story with the SLAPP suit legislation that many of you know. But I just want to say, like, the reason that this bill has been killed over and over again is because, among other things, it is a law that in effect protects wrongdoers often. And by wrongdoers, it's people who are defaming other individuals, who go out on blogs or, even in newspapers, but certainly online, and say horrendous things about people, and then try to justify it that it's somehow in the public interest or if it's against a public official. So let me just tell you quickly the story. A few years ago, my daughters and I and my wife, we went to the Ravens game out in London, where we unfortunately lost the game, but we had our picture taken. My girls and I had our picture taken by one of these, by NFL Europe. It ended up online somewhere in one of these places that people come and take down photos from. And to make a very long story short, weeks later, an individual was videotaped looking for prostitutes at a different Ravens game. It was a heavyset gentleman with gray hair, which became somewhat relevant later on. And this company, so somebody took this thing and was like, ha ha ha, look at this heavyset guy looking for prostitutes at a Ravens game. And they put that online. And to make a long story short, it bounced around the internet, which of course has nothing to do with me. But then a company in California, where they have a similar law, got a hold of this, and they made a whole thing of it and made another thing where they could try to make some money. And what they did was they found the picture of me and my daughters from NFL Europe. Somehow they came across that because they were looking online for pictures of a guy in a Ravens shirt with kids to try to make something juicy of it. And they put online that it was me that was looking for hookers at a Ravens game. They had my picture up with my finger in the air, with my daughters wearing our Ray Lewis jerseys. And they said, with the video rolling, this individual was caught looking for prostitutes, which of course was untrue. And as we sued them for defamation, and as it turns out, they admitted that it was untrue. I mean, which I'm sure their lawyers were not pleased about. They admitted that they were just simply looking for something juicy. I mean, it was a horrendous thing. And so we filed a defamation lawsuit. They removed the case to California because that's where, A, they were from, but also, B, they have this great thing called a SLAPP suit. And it was very similar to this. And they filed a SLAPP suit motion. And they claimed in their motion that because this was something of, quote, public interest, right? Somebody looking for prostitutes, that's of public interest. And that I was a public official which of course they didn't know at the time. They just found some random picture. That this should be thrown out, dismissed, because it was a SLAPP suit. It was a strategic lawsuit against public participation. My lawyer was forced to tell me, look, we think that it's not true. They didn't know you were a public official. And obviously, we're going to win a defamation suit. But if you lose their motion, not only will you lose the case and they will have been allowed to defame you, but you will then have the further indignity of paying their legal fees, which is what this bill seeks to do. When we killed, which would have been outrageous, this bill protects bloggers who say things about each and every one of you, your families, and you can file this SLAPP suit. There is already under the law bad faith, right? I have filed that many times. If somebody files a frivolous lawsuit, you can file a bad faith motion against them. But the idea that, for example, on page 4 of your bill, number 3 there, where it says, if it appears likely that discovery, essentially what you're saying is, in my case, I couldn't even get discovery unless I could convince the court that I needed discovery, and I would have to pay the defendant for the right to do that discovery, simply because they filed a SLAPP suit motion against me. This bill, we killed this on the floor. Senator Miller and others came out very strongly against it at the time on the floor, because this bill, in its essence, protects wrongdoers. If somebody, sorry, if I could just finish real quick. Can you still hear me, Senator Waldstreicher?
Yeah, please just go ahead and conclude.
I'll finish up. In its essence, if a blogger says something about Senator Waldstreicher, which they know is defamatory, just because Senator Waldstreicher is a public official, or his wife, because she's the wife of a public official, that is not cause for you. Like, it is not open season on you because of these things. And I get it. The Washington Post and others, Yelp used to come before us. I don't know who's there today, but they all want more protection than they always get. They want to be able to say, this is the person who did the Olympic bombing. This is the person who is, a racist and screaming at somebody or whatever, even though they weren't. And they want protection from that, because they want to be able to say, look, you're just suing us because, we're just doing the thing in the public interest. This is a bad piece of legislation which has been killed for a long, long time for good reason. We have a SLAPP suit here, and we have the ability to get rid of frivolous cases. Thank you very much for hearing me. I appreciate it.
Thank you, Senator Zirkin, for your testimony today. We'll move on to Ms. Laura Bogley. Ms. Bogley.
Thank you, Chairman Smith and Vice Chair Waldstreicher, members of the committee. I'm Laura Bogley, Legislative Director for Maryland Right to Life. On behalf of our members across the state, we respectfully ask for your unfavorable report on Senate Bill 315. In its wisdom, this assembly passed the original anti-SLAPP statute to avoid frivolous lawsuits and to protect the freedom of speech for all of Maryland's citizens without qualification. But the bill before you asks you to use your authority to weaponize the courts against certain speech and speakers using an undefined and subjective judgment standard. Apparently, the original bill had some unintended consequences or unintended foes. And so now you are being asked to build in loopholes and exceptions to the application of the statute. We are here again this year because a Catholic high school student attending the National March for Life in 2019 was awarded legal settlements against 2 national media outlets who accused him of hate speech simply because they disagreed with the boy's deeply held religious beliefs. Obviously, well-funded corporations have the resources to file frivolous lawsuits and drag out litigation. This bill gives them the legal loophole to do just that and leaves individuals and nonprofit organizations defenseless. This bill is a slap in the face of justice, and we urge you to vote no once again. Thank you.
There we are. Thank you for your testimony. Dr. Walton, you're up next.
Hi there. Hi. Thank you. Good afternoon, Mr. Vice Chair and members of the Judiciary Proceedings Committee. I'm not a member of the Washington Post. I'm just a little guy. My name is Dr. Jay Walton. I'm the leader of 40 Days for Life here in Lutherville, Maryland. I'm here to testify against this proposed version of the SLAPP law, Senate Bill 315. Indeed, the current law is good just the way it is. As someone who organizes prayer vigils on the public sidewalks in front of abortion mills, the current SLAPP law protects me and my volunteers from frivolous lawsuits and upholds my First Amendment right to freedom of speech. For example, imagine that your child is praying outside, just praying outside, not at a prayer vigil or anything. Someone gets offended by your child praying and goes to the local newspaper and says that your child is a white supremacist. That seems to be pretty popular. Under the current version of the bill, you could sue the newspaper for libel, slander, defamation, and simply say, look, these accusations against my child are false, they're dumb. The newspaper didn't like my child praying, so they slandered my child's good name, and we demand some relief. However, under the proposed legislation, this bill would weaken the original statute and create a huge legal loophole for news outlets and other actors to evade legal liability for acts of libel, slander, and defamation. Make no mistake, this bill is an attempt to suppress pro-life speech and scare people into silence. The media will have free rein to slander and defame pro-lifers or anyone they disagree with. Senate Bill 315 is just bad public policy. I respectfully urge you to protect our First Amendment rights, the little people here. Please protect our rights by rejecting Senate Bill 315 and its broad expansion of SLAPP suits. Thank you.
Thank you, Dr. Walton. That concludes the testimony from both the proponents and the opponents. Again, my apologies for moving the questions to the end, but we are now at that point. So questions from the committee. All right, seeing no questions, that concludes the hearing for Senate Bill 315, and that concludes the hearings for today. We'll see everyone again tomorrow. Thanks so much for joining us.